¿Cómo ubicarla en YouTube?
May I please your Lordship?
Yes.
Lordship, I'm praying for your Lordship's indulgence. I'm praying to upgrade item number 5 to PIL, Lordship. After item number 1, my Lord, the item 2 and 3, it may take some time for hearing. It may take, if taken up, it may take the whole day also. My Lord, the matter relates to Dimapur Kohima Highway, item number 5. And in view of the long roadblock, my Lord, I would like to raise certain issue. The problem is, Lordship, this matter cannot be taken up by Honorable Justice KSMA. So the last time that this matter was listed in the month of May, and it is coming today. He appeared, he was the counsel for the government earlier, before he was elevated.
I see.
So, my Lord, my respectful submission is that let it be upgraded after item number 1 on public interest. I would like to raise some important issues, urgent
Okay,
issues.
if the other councils for the other case
Lordship, it will take few more.
object to it,
Yes,
then upgrade it.
because item 2, we are there. If taken up, it may take some time.
So Jamil,
My learned friend was also sharing that. He said it will be a short matter. I'll take a short time, so I would like to upgrade. I have given the concern. Yes, this is important for all of us.
all right.
No problem.
May I please, my lords?
Yes.
Lordship, item, hearing item number 19, Lordship, 19.
Yes. What do you
Lordship,
want?
may it be listed after 2 weeks, Lordship. I've taken the consent of the other party, Lordship.
As paid for by Mr. K. Angami, learned counsel for the appellant, and not objected to by the other side. You're the PP, isn't it?
Lordship,
Learned public prosecutor, appearing for the appellant and not objected to by the other side. List the matter again after 2 weeks for hearing.
Lordship. Lordship, item number 21, Lordship. Lordship, may it be listed after 3 weeks. This also I've taken the consent of the other party, Lordship.
Okay, similar
Lordship.
order.
Yes, 3 weeks, Lordship.
Make it 3 weeks, okay?
Lordship.
Instead of PP, right, state council, okay?
Lordship.
Blashman.
May I please, Lordship?
Yes,
My lord, I beg to mention item number 6. I'm mentioning on behalf of V. Zumomi, my lord. Kindly allow 2 weeks time to file affidavit.
6.
Yes, my lord.
It's a criminal appeal. It's a criminal appeal.
Yes, my lord.
What affidavit you will file?
So let the matter be come up after 2 weeks, my lord.
No, that's okay, but you're saying you want to file
Yes,
affidavit. What kind of
I was
affidavit?
instructed by my colleagues. I think.
You are praying on behalf of Mr. Zo
V. Zumomi.
or VC Momi. He's
Yes,
the
ma'am.
state council.
Yes, my lord.
Any objection?
No objection, Lordship.
Okay. As paid for by Mr. E. Tivapo, Lanet State Council, on behalf of his colleague, Mr.
V. Zumomi.
VC Momi, appearing for the state and not objected to by the other side. Matter stands adjourned for 2 weeks.
My lord, again, I beg to mention item number 8 on behalf of LD Sangdam, additional AG, my lord. Kindly list the matter after 1 week.
Item 8.
Yes.
Yes, you are there? Any objection?
No, Lordship. Lordship, let the matter be taken as per the list, this matter.
Okay.
Okay.
Much obliged. May I please, ma'am?
Yes.
Lordship, I beg to mention hearing item number 16 on behalf of additional GV Shokre, Lordship. Lordship, she has some difficulties today. If this matter can be listed after 2 weeks, my lord. I'm informed that she has informed the other side, my lord. Item 16.
Mr. TV Jamier's case. Any objection?
No objection, Lordship.
After 2 weeks, you said,
Lordship, after 2 weeks.
as paid for on behalf of Ms. V. Shukre Lanet, additional AG, Nagaland, by Mr. N. Angami,
Lordship.
Lanet State Council, and not objected to by the other side. Matter stands adjourned for 2 weeks. Yes.
Obliged, my lord.
Please, your Lordships. My lord, I beg to mention here in item number 18, Lordship. Here, I'll be filing power in respect of opponent number 1, Lordship, today. So let this matter be listed after 4 weeks, Lordship.
Where's Mr. Z? Any objection?
No, my lord.
After
4 weeks, Lordship.
4 weeks?
Lordship.
Why? So
Go
such
through
a, this is a writ appeal. You need not file any affidavit also.
Lordship, after 3 weeks.
What is your good name?
W. Marshall, Lordship.
Mr. W. Marfu, Learned Counsel, submits that he has instructions to appear on behalf of respondent number 1. And prays that he may be given 3 weeks' time to file his power and to obtain instructions from his client. Stop Mr. Z. N. Muli, Learned CGC,
Yes, my lord.
appearing for the state of, appearing for the appellant. Appellant has no objection. In view of above, this is the matter again after 3 weeks.
Much obliged.
May I please, your lordship? My lord, I beg to mention item number 3 and 4. I have not received any instruction yet. My lord, so that this matter will come after 2 weeks, my lord.
Objection, my lord. This is habeas corpus matter. A single day is too many, and I've been illegally detained for nearly 3 months now. Therefore, the matter may kindly be heard today, my lord.
Last time also,
Yes, last time also date was given.
you had given some time to you.
It's one week,
Sorry?
1 week, my lord.
Yes.
Yes,
You still have not received instructions.
yes, my lord.
Let the matter be called, we'll see. Okay.
This one.
Please, your lordship, I beg to mention item number 9 to 11. I pray that this matter may be adjourned for 2 weeks. My senior has an urgent matter today, so thus the matter may be adjourned for 2 weeks.
Yes, I think he's on the screen. Mr. Zimomi? You want some adjournment?
No, your lordship. I'm for the petitioner and Mr. Easy.
Why, sorry, you are for the
Respond.
respondent, I'm sorry. Respondent in all the cases?
Yes, Your Lordship.
Any objection?
No objection.
All right. After,
2 weeks.
that's paid for by the learned state council. The learned council for the respondents. Respondent, actually. Respondent to respondent.
Respondent, there's only one respondent.
Your Lordship, they are the sole respondent in with appeal 6 and 14.
Now, what about this with appeal 7?
Your Lordship, the state is a sole party in that
That's
case.
why. That's paid for by the learned council for the respondent in WA number 6 of 2024 and 14 of 2024. And not objected to by the other side. Matter stands adjourned for 2 weeks.
Yes, Your Lordship. Similar prayer for item number 20.
Item number
20.
20.
Yes, Your Lordship.
In this case, you are for the respondent again.
Yes, Your Lordship.
Respondent means private respondent.
Private respondent, 3 and 4.
Yes, Mr. Iralu, any objection?
No, no objection.
As paid for by learned counsel for the private respondent, private respondents, and not objected to by the other side. Matter stands adjourned for 2 weeks.
2 weeks.
Right.
God bless you, Lord.
May I please, Your Lordship? The appellant counsel have requested me to seek adjournment since he did not travel.
Which council and which item?
Appellant counsel, hearing item 15.
15. Yes. Counsel for the appellant.
Yes, my lord.
Who's for the respondent?
It will be for respondent.
Oh, you're praying for respondent
Yes, my lord.
and you're praying for the appellant.
No, I'm submitting that because they have personally requested me.
Okay,
to
when?
seek adjournment for both the parties.
When?
3 weeks, my lord.
There will be a joint prayer as paid for by the parties.
Yes, my lord.
It's the matter again after 3 weeks.
Hello, Michael.
For motion, item number 22.
May I please, Your Lordship? Lordship, the petitioner is challenging his detention under the National Security Act. There are several grounds here, Lordship, but the glaring irregularity is that the detaining authority has said that he's likely to move bail and therefore he needs to be detained.
Where is
Lordship,
the order?
Lordship, at page 53. And the grounds, Lordship, at page 54. And the particulars, Lordship, is at page 55. Lordship, may I kindly come to page 59, the relevant portion, where the reason for his detention is given. Lordship, may I kindly come to the last paragraphs. The second last paragraph, may I read the last line?
Yes.
The subject is a habitual offender and has also been shown arrested in connection with Dimapur West PS case number such and such under section 384/34 IPC, read with section 7 NSR. Lordship, the detaining authority has referred to another case, a police case, Dimapur West police case, but this particulars has not been furnished to the petitioner. That itself is a ground which vitiates the detention order. And therefore, and again, Lordship, may I kindly see the paragraph number 4. The subject, Mr. Such and such, is a habitual offender and is presently under judicial custody at Central Jail, Dimapur, and is likely to move bail. If not detained, he is likely to indulge in similar prejudicial activities unless an effective alternative measure is called for. On examination of the report forwarded by the sponsoring authority, the subject is found fit to be booked under the National Security Act 1980. Hence, in order to prevent him from indulging in activities prejudicial to the security of the state of Nagaland and maintenance of public order, the undersigned has ordered the detention of the subject under the said act. Now, Lordship, he has not even moved bail. The petitioner has not even moved bail. It is a subtle law that yes, a person, even if his bail does not move the bail, he can be detained under the act, but the particulars, the reasons why the detaining authority feels that he'll be released on bail, that has to be given. Now, in this case, even the bail application has not been moved, and this itself vitiates the detention order.
Is it necessary to move a bail application?
No, Lordship, but in Rekha case, Lordship, reported in 2011.
If there is an apprehension of the detainee moving a
Yes.
bail application, isn't that sufficient?
Yes, but Lordship, the particulars has to be given. Whether a co-accused has moved a bail, what is the, this particulars has to be given. If this particulars is not given, then the detention order is vitiated, Lordship. That's a ground for setting aside the detention order. The Supreme Court has said this in the Rekha case, Lordship, in 2011. And also the case
So
from Manipur, Lordship.
Will issue notice?
Khodiram County.
Will issue notice?
Yes, Lordship.
You are Mr. Longjem.
Yes, Lordship.
Heard Mr. Imti Longjem. Heard Mr. Imti Longjem, learned counsel through VC, who submits that by filing this writ petition, the petitioner prays for issuance of a writ in the nature of habeas corpus for being illegally detained by the respondent authorities. The learned counsel submits that the petitioner has challenged the detention order dated 13/5/2024, the approval order dated 22/5/2024, and the confirmation order dated 9/8/2024. The learned counsel further submits that the petitioner is said to be an habitual offender, and he has been shown to be arrested in connection with Dimapur West PS case number 0030/2024 under section 384/34 IPC read with 7 NSR. However, copy of the relevant materials have not been furnished to the petitioner, and that the petitioner has not even applied for bail. Therefore, the impugn orders passed by the respondent authorities should be set aside, and the petitioner should be set at liberty. Next para, issue notice, the motion returnable by
3 weeks, ma'am.
3 weeks.
2 weeks, Lordship. Lordship,
2 weeks, okay.
kindly
2 weeks.
kindly 2 weeks. Yes.
Detention. Okay. 2 weeks. Mr. E. Tivapom, learned State Council accepts notice on behalf of the
There's one, two, three, and
respondent
4.
numbers 1, 2, 3, and 4. And Mr. Gauhati, learned CGC accepts notice on behalf of respondent number 5. Petitioner serve requisite extra copies of the writ petition to the learned councils appearing today within 2 days, if not already done. This is the matter again after 2 weeks, the respondents to file their objection. In the meantime, and the learned councils appearing for the respondents shall also obtain instructions in the matter. Registry to list accordingly.
Obliged, ma'am.
For admission, item number 1.
Those to be upgraded. After 1. Okay. Okay. Yes.
Your Lordship, the
Where is the
authority engineer.
status report?
That's why it's the counsel for the authority engineer has gone to file. Apparently, when he went to file earlier this morning, it couldn't be filed. We have received the copy, but your Lordships are yet to receive the same copy we have received. I do not know whether my learned.
No, why is it
senior
always
also has
filed on the
received or not.
day it's listed?
Hello?
Why can't it be filed 1 day ahead? isn't it?
See the copy. Yes, my lords, I received the copy this morning also. Just this morning. Of course, I haven't got a physical copy yet. My junior has received it this morning.
Without having a copy of the affidavit and the assistance of the amicus, I think it'll be difficult. Isn't it?
My lords, may I pray that the matter be listed on the coming Wednesday?
There's no issue regarding this matter being taken up by a different bench?
No issue, my lords.
Okay.
No issue.
We have it then.
Yes.
On
Despite my
Wednesday.
best efforts, I could file only this morning, my lord.
Okay. Mr. Senti Younger, Learned Counsel for the respondent number 10.
10.
Submits that he has filed the affidavit of the authority engineer this morning only. Since you could not get the instructions sooner. Since the copy of the affidavit is not on record and that same has also not been perused by the learned. We deem it proper that the matter be listed again in the coming Wednesday. Please to verify the affidavit file and tag it along with the record. In the meantime, list the matter again on. What is that date? It's 4th of September.
Much obliged, my lords.
For admission, item number 5.
Yes.
Yeah, please, your lordship. Lordship, before I take up the important issues of public importance, kindly allow me to give a background. The matter relates to this Sumutu PIL was registered in the year 2019. The matter relates to 4-lane construction from Dimapur to Kohima. Lordship must have opportunity to take up this matter in the past. It is divided into 3 packages. Package number 1 and 2 constructed by Ramge Lordship, and package number 1 and 2 has been completed, and the Ramge, the contractor also was discharged. But thereafter, my lord, the issue of rock fall right after Patkai, we call it Pakala Bahar. My lord, I will raise that issue because it has become a serious issue. 1. For the 3rd package, that is starting from Dimapur, Lordship, initially the work was ordered to Gauhati, one contractor. He abandoned the project. Thereafter, the work was allotted to another contractor, Oasis. The second contractor also abandoned the project. Then the G20 came. So, Lordship, the maintenance contractor was allowed by this honorable court to blacktop the 2-lane, where presently we apply. And since he was able to do a good job in a record time, and in view of the bitter experience of the 2 contractors abandoning the project, it was suggested before this honorable court that why not we allow the then maintenance contractor to complete the project, because by then he has already completed 2-lane. So this honorable court was agreeable with that proposal. And on 31, by an order dated 31/3/2023, before Honorable Chief Justice and Justice LS, a direction was issued. Initially, my lord, we suggested that why not Ramge be allowed to continue with the project, but then the 2 packages were completed. So negotiation was done, but then you were not able to come to an understanding. So second option was, why not the local contractor who was maintaining the project to complete it? He was willing. Accordingly, appropriate direction was given on 31/3/2023. However, Lordship, the NHITCL being aggrieved that it was not, the work is not allotted through a tender process. He went in appeal to the Honorable Supreme Court in appeal. And thereafter, Lordship, the Honorable Supreme Court by an order dated 15/4/2024 quash and set aside the order dated 31/3/2023 and give a direction that the NIT should be issued and for timely completion, and then the Honorable Supreme Court also give a further direction to the NHITCL to appoint a nodal officer who will ensure that the work is completed by September 2025. Then a new contractor, the present the contractor Eagle, Brown Eagle is now the contractor from Arunachal. Lordship, accordingly, my lord, a nodal officer was appointed by the Honorable Supreme Court, by the NHITCL, and now it is under construction. And Lordship, the Honorable Supreme Court had also directed the nodal officer to file an affidavit before this Honorable Court. Now, Lordship also kindly appreciate that after the Honorable Supreme Court quashed and set aside the order of the Honorable High Court, the Honorable High Court by an order dated 10/5/2023, that is before the Honorable Chief Justice, the case was, PIL was closed sine die with a direction that as in when desired, the case can be revived before Kohima, before this Honorable Kohima bench. That was the direction.
10/5/2023.
10/5/2023.
After the order of the Supreme Court.
Yes, after the order of the Honorable Supreme Court, Lordship,
Yes.
Lordship, I can, my lord, kindly allow me to read for the benefit this order. My lord, the officers in the last line only, my lord, I am reading. Lordship, may kindly see 10/5/2023 if the order is before your lordship, 10/5/2023. Before Honorable Justice, Honorable Chief Justice, and the last line, last two lines.
Just a minute. Yeah, that's the one.
Yes.
Yeah, yes.
Yes, the last two lines only, Lordship. Now, the case was closed anytime on Lordship 10/5/2023. However, my lord, in view of the direction of the Honorable Supreme Court, my lord, in the compliance affidavit, in the affidavit filed by the Lordship nodal officer.
This PIL was initially taken up in the principal seat.
No, here. But my lord,
Then,
my lord, what has happened is we were facing difficulties in view of the fact that my lord K.S. Imam could not take up the matter. He recused.
okay.
So in that backdrop, the Honorable Chief Justice thought it, he came here also that time, at that moment of time. So in that backdrop, in view of the importance of the matter issue, the matter was transferred to principal seat and continued there.
Okay.
Now, my lord, in view of the direction of the Honorable Supreme Court, which is, my lord, if my lord may kindly see the compliance affidavit, the affidavit filed by the nodal officer, an affidavit filed in compliance of the Honorable Supreme Court's order dated 15/4/2024, directing to nominate a nodal officer. It was filed in the month of May. My lord, that affidavit should be there.
It's not before us.
My lord, filed by the nodal officer. My lord, it was filed in the month of May 24. My lord, it was referred the other day also. Definitely. Now, my lord, kindly allow me to read the operative of the Supreme Court. May I read?
Yes.
Given the background of the case, we direct the appellant, NHITCL, to file an affidavit before the High Court nominating a nodal officer who will be overseeing the execution of the work. The nodal officer will ensure and be responsible for completion of the work within time and in accordance with the agreement. Lordship has found the affidavit? No.
No, no. These are just a bunch of orders with us.
But Lordship, Lordship, yes. My lord, I can supply a copy of the judgment.
Which judgment?
The Honorable Supreme Court. Is, if you have, when did you supply?
15/4/24.
Yes. But my learned friend have extra lordship, that this can be, your lordship may kindly see. That will serve their purpose.
Just a minute. It's here.
Yes.
Judgment is here. I was talking about the affidavit. Affidavit is not before us.
No,
Only the order is here.
order is there besides that, my lord, the affidavit filed by the nodal officer, my lord, it was served to me. And the other day also, this was referred.
You want to read the order?
No, lordship, just to satisfy your lordship, the last order, that in view of the direction given by the Honorable Supreme Court to the nodal officer to file the affidavit, lordship, the case was listed on 26/5/2024 before the Honorable Court again. That's how the case was revived. Not because of any order by this Honorable Court. That is what I would like to bring to your lordship noticed. By chair.
It says we direct the appellant at HRDCL to file an affidavit before the High Court,
My lord, the affidavit is here.
nominating nodal officer who will
Yes.
be overseeing the execution
Yes.
of work. Then you want to read the affidavit?
No, my lord. That is the one. My lord, the affidavit is filed by the nodal officer is there. Here.
You want to refer to that?
Yes, my lord. Because just to bring it to your lordship notice, that the affidavit, that is the last affidavit in compliance with the direction. This was filed. However, my lord, now that is the position at the moment.
What is written in the affidavit?
Not, my lord, he is only relating about his appointment and to ensure that he will, my lord, paragraph 5 only, that I further state that NHITSL shall make its best effort to have the said project completed within the time frame by the end of September 2025. That is the only thing. Above that, my lord, he's talking about the direction of the Honorable Supreme Court. So that is the position today. Now, my lord, on the last occasion, when the matter was listed, the contractor, Grand Eagle was also implemented as a respondent. Thereafter, my lord, now, my lord, thereafter, what is the progress of the work position?
The respondent number?
15.
15.
Yes.
And this affidavit is filed by the
Nodal officer.
Nodal officer, who is the respondent number 7?
6 and 7.
6
On
and
behalf of NHITSL, actually, my lord, I feel that the nodal officer also should be implemented separately because 6 and 7 are the NHITSL. In terms of the direction, madam, nodal officer has been directed, so now he's responsible. So I'll come to that.
He says he's the respondent number 7.
Yes, respondent number 7 is the NHITSL,
Then who is 6?
Union of India.
Okay.
Now, in terms of direction of the Honorable Supreme Court has given a direction to specifically appoint a nodal officer, lordship, who shall be responsible to oversee the project to ensure timely completion.
So the NHRDCL and the nodal officer cannot be the same.
My lord, because personal responsibility has been imposed on the nodal officer by the court's order. Under the direction of the Honorable Supreme Court, the nodal officer is appointed.
Yes.
So that is one aspect of the matter to be considered today. Secondly, lordship, with the new project, a new engineer, authority engineer is appointed, lordship. Because every contractor, with the appointment of any new contractor, my lord, the old authority engineer who was overseeing the three projects, my lord, his term expired, I'm informed, and I'm told that a new authority engineer has been appointed. So the new authority engineer has to be implemented as a party respondent in the case, without which, my lord, will not be able to have an idea of how the work is progressing. So, my lord, implement of the nodal officer who is responsible for timely completion as directed by the Honorable Supreme Court, and the new, my lord, authority engineer should be implemented as party respondent. That is my first submission. Secondly, lordship, and in fact, and with a prayer that on every time the matter is listed, a direction should be issued that these two officers should be present in the court so that we get update information in future. I mean, after the implementation of the nodal officer and the authority engineer, earlier also that was a practice that every time they were directed to be present, so we know every progress from them and to receive instruction from the NHITCL. Now, my lord, that is one aspect of the matter. Now, on the issue of, my lord, the landslide, which has happened. It's about 2 weeks, and we are facing the Bram situation. My lord, the landslide which has happened at JNH 164 at Zuda, DZA, at JNH 164. Now, my lord, it's about 2 weeks since the road is blocked, and we are yet to see the light at the end of the tunnel. This is having great public importance because, my lord, not only for Kohima, my lord, but for Manipur. This is a lifeline. Now, my lord,
This is NH, what is the NH number?
NH 164. No, JNH 164.
No,
NH,
National Highway
NH 29.
29.
National Highway 29, Dimapur, Kohima, 4-lane. Package 3 construction at JNH CH 164. Now, my lord, even after 2 weeks, where it is yet to be cleared. Now, my lord, from the media, it was reported that for 2 days there was stoppage of work in view of my lord, certain issues between the NHITCL and the contractor on the ground, the Brown Eagle. On verification, lordship, the very important issue raised is, my lord, the scope of work. Whether to clear such a big landslide, whether it is covered within the scope of work of the contractor, Brown Eagle, who is constructing the project at the moment. In view of the dispute on the issue on scope of work, my lord, it seems it was stopped for 2 days. Now it is continuing. Now today, I'm told that there is another contractor who is responsible for maintaining the slopes.
I see.
But that contractor, maze-free infrastructure development. But unfortunately, the NHIT is also on the last occasion, this was not a subject matter to be discussed, so we did not implement them as a party respondent here. And the implement will be necessary to ensure that the progress. I think the response, NHIT can kindly give the right spelling, the project to the, you can give to his lordship now. Kindly give to his lordship. So, my lord, so that his implement of that maintenance of the slope contractor is necessary to ensure, to find out who is responsible, what is the scope of work, because unless and until that issue is settled, my lord, will be
How do you pronounce this? Makaferi.
Mecca ferry. Okay. So, my lord, So so that the concerned company is required to be implemented as a respondent in the present case. Anyway, you can, yes. That, No.
Can you just write in a piece of paper and pass it on? Andheri, what is this? Kerala Road? Kunal Road or what? Difficult to make out the spelling. You just write it down somewhere and you pass it on. Yes.
So that is an area, so that is one. Now, Lordship, the area of concern is this. My Lord, I also have been to the spot. I had personally visited the spot, and Lordship, from the top, there is a heavy flow of water. It is quite probable that there is a spring inside. So, my Lord, unless and until proper drainage is constructed on the top and water is diverted by using muck pumps and divert the water to the river. Even if road is clear tomorrow, that will not solve the problem, because unless the proper drainage and water is diverted from the dome, we'll continue to face problems. And below the road, my Lord, in fact, every day it is updated in the social media also, there are big cracks has been developed. So far, the main road is not sinking, only the above the road, the whole, my Lord, chunk of land is sliding. It is not a small portion, but the whole area is sliding. So far below the road, my Lord, it seems to be stable, but I could see cracks. In fact, this morning also I was watching the update in the social media. My Lord, there are cracks being developed below the road. So unless some measures immediate measures is taken with monsoon, by October, the land below the road may also go. So, my Lord, there is a grave concern to ensure that the drainage of water from the top, and, my Lord, another issue is stone quarry.
Where's the stone quarry?
My Lord, in the area. That is what I'm informed. Because as per the local, as per the report, my Lord, stone quarry is also a concern. That issue is also was there in the social media. In fact, Geology and Mining Department, who had visited the area, also had raised these two issues of water drainage and stone quarry. So, my Lord,
where is the stone quarry?
My Lord, within the vicinity of the landslide area. So unless that is controlled, my Lord. Now, my Lord, it is learned that the state government has issued an ultimatum to the contractor on 26/8/2024 to ensure that the work is completed within 3 days. But if the Eagle company is not responsible for slope maintenance, it is quite probable that the state government are parking at the wrong tree. Because unless and until so we have to ascertain who is responsible to maintain, whether it is the company who is maintaining the slope work to do the needful or the construction company. So that is what, now also, Lordship, I would like to know from the respondents, how many machineries and manpower is there on the ground at present working on that side to clear the debris? Because unless until if sufficient machineries and manpower is available by now within 2 weeks, that should have been at least GPB road could have been opened by now. That is also an area of concern. So, my Lord,
which is the contractor which is undergoing the work? Brand Eagles.
Brand Eagles. Brand Eagles are, my Lord, now the Brand Eagles are raising the issue of scope of work, saying that maintaining and clearing all the landslide and maintaining the slope is not within your scope of work. That's how, my Lord, there was stoppage of work for 2 days, as per the media report.
I understand. See,
yes.
Brand Eagles are basically engaged for this package 3.
Yes.
Not for other packages.
No. And landslide is within package 3.
Landslide is within that portion of
yes.
the package 3. Now, Brand Eagles are doing the construction. work.
Yes,
But when the landslide has occurred, huge piles of earth spoils have come down.
exactly,
And they're questioning that whether this can be the scope of work.
exactly, Lordship.
If
But-
it is not, why are we doing this?
Exactly, the council is here, Lordship.
Who is going to pay for us?
Yes,
That perhaps is what they're questioning.
yes, Lordship.
But in between that, now you say that this particular measures Macquarie,
Yes.
they are the one who are to maintain the slopes.
So, my lord, another issue is.
What is the understanding between the
That is-
NHIDCL and Macquarie?
My lord, that I am not aware.
No, from where have you got this information?
I mean, I got the information from the documents.
Is
that-
there an agreement as such
Yes, Lordship, as
that
per
they'll
the,
maintain the
Yes.
slopes?
as per the contract of agreement,
Hmm.
that was signed by the Brand Eagle with the.
You are for Brand Eagle?
Yes, Lordship. Now, under the scope of work, the maintenance of the slopes
Hmm.
is to be maintained by another agency.
Hmm.
So we got information from the NHIDCL saying that it's McCaffrey who's supposed to, in different pockets, Lordship.
Then why they have not been employed all these days?
Lordship, that's how we are questioning the NHIDCL. Because we are the one who is assisting.
No, it seems the NHIDCL is not interested at all.
They, apparently-
NHIDCL is not interested at all, and even the Brand Eagles also
No,
perhaps.
Lordship, we are.
Perhaps you are trying to say that this is not our
But still. we
job
have-
to clear the
Yes,
thing.
We have put up our machineries, Lordship, which is in the site. It's our machineries that is working. This McCaffrey, none of them they have come till date, Lordship. None of
Why,
them. are-
why that has not been pointed out
No,
earlier?
Lordship, that's how we have stopped the work, as stated by my learned friend. But a direction was given to us,
No, how did you discover? When did you discover about that?
Lordship.
Because you were working earlier. You said you were working, you had put the machineries in the
Yes.
place.
We are for the maintenance of the existing road and the
Correct.
four-lane.
So you've been clearing the debris and all that. But all of a sudden, last 2 days, you stopped work. How did you discover that this is the company who
Lordship,
maintains the
as per our
slopes?
contract agreement, we were just assisting as directed by the NHIDCL, Lordship.
Okay.
As directed by the NHIDCL, we have given our machineries. Now, the question lies with the NHIDCL, Lordship. Why
No,
they are,
my question is, when did you discover there's a particular company
No,
who is
it-
supposed to maintain the slopes?
Lordship, it was already there.
If it was already there, why didn't you raise this issue earlier?
Lordship, we were.
Instead of blindly
we-
clearing
we-
that thing,
We were
debris.
inflated only in the month of May, and the matter is coming up today only.
That is the problem. Lordship.
No, your implement in this writ petition is something else. I'm saying you are on the ground, you're working,
Now, Lordship,
you're doing the four-lane working, isn't it?
yes, now since.
Now, if this kind of situation has arisen, then the first question you would have raised was that only.
Yes.
Since we are here to construct the road, not for maintenance and clearing the slopes and all that. So when did this occur to you?
No, Lordship, we could not apprise the court because the matter is coming up only today.
No, his lordship is asking, when did you bring it to the notice of the NHIDCL, the authorities concerned?
No, Lordship, that I have to get instruction, Lordship. But as per our contract agreement signed with the NHIDCL, this slope maintenance has to be done by another agency. The
No,
name
that-
is not there. The name
That
is not.
don't repeat that again. We have understood that already. We have understood that. I just wanted to know, when did you come to learn about this? That there's another company who's in charge of this slope maintenance.
On the day that the agreement was signed, Lordship.
What was that?
Lordship, I may be allowed to extract the.
Just tell us, when was that?
Lordship, it's a very bulky document, Lordship. This is a contract agreement that was signed, Lordship.
When was it signed?
Lordship, if I may, Lordship be allowed to take me to the.
Eighteen point three, Lordship. Hill slope stabilization works to be taken up by a separate agency.
September 2023. No, Lordship, may I kindly tick the operative part, Lordship, the 12th portion, landslide. Lordship, the next page,
This is-
18.3.
What is this document?
It's a part of the contract agreement, Lordship,
Between whom?
between the Brand Eagle and the NHIDCL.
Okay.
So in that 18.3 clause, Lordship, may kindly take note of that, Lordship. 18.3, hill slopes mobilization work to be taken up by separate agency.
That much only. So who's
Yes.
that agency?
We didn't know about it, Lordship.
Hmm.
Now on on query, we have been informed that it's McCaffrey. And as per information, Lordship, none of this technical person of the McCaffrey is present in the site till date. And we are doing the work.
What is the scope of this work assigned to the company? This, what do you call this? McCaffrey.
McCaffrey, Lordship, as far as we know, it's the maintenance of the slope.
Well, that we know. You said that.
Beyond that, we don't know.
Maintenance of slope is it's a very, you know,
Exactly,
like-
Lordship.
Yes. It's very vague.
Exactly,
Maintenance of slope,
Lordship.
how much? To what extent?
Lordship, that
And how they are supposed to maintain?
NHIDCL
That we'll have to know.
Yes, the NHIDCL will be in a better position to explain.
We'll
that.
ask them.
Yes, Lordship.
But right now, I think your job is to say that we are not responsible, they're responsible. That much.
No, Lordship. We are saying, in spite of not being in the scope of the work, we are giving our assistance as directed by the NHIDCL.
That's good.
We are doing selfless job, Lordship.
But what kind of job you are doing? See,
Clearing the debris, Lordship.
since how? Since
Because
when?
since our scope of work is not.
Since when and how much? How many
Yes,
machineries?
that
are
is the
you putting?
issue. That is the issue, Lordship.
Lordship, our
Half-heartedly you're clearing, I think.
Lordship, as stated by my learned friend, Lordship. Now, it's not just a block of the earth that is coming down, Lordship. It's the whole mountain block. If we clear today also, the next morning, the whole junks come down.
My lord, on this issue, on the question of machinery and manpower on the ground, in view of the, my lord, importance of the road, besides the machineries from the contractor, what steps has been taken by the NHIDCL, whether they have brought any extra machineries or any manpower to the ground, or they are solely depending on the contractor on the ground, or for that matter, what is the step taken by the state government? Last 2 weeks, the only thing I could see, the state government issue a ultimatum on 26/8/2024 to NHIDCL. Besides that, last 2 weeks, what steps have been taken by the state government as well as the NHIDCL, or solely depending on the contractor on the ground and the machineries of the contractors? And the public are left at the mercy.
Okay, Mr. Takamasa.
Lordship.
This PIL has been taken up so moto, isn't it?
Yes.
It pertains to this particular NH29, Dimapur to Kohima.
Lordship.
And which comprises of different packages.
Yes, Lordship.
3 packages.
3 packages.
Lordship.
Now, at the moment, we are concerned with this package 3 because that's where the massive landslide has occurred, isn't it?
Yes.
Yes.
And the contractor who's executing work to that stretch of the road is yourself,
Yes, Lord.
the Eagles, Brand
Brand
Eagles.
Eagles.
And despite you not being one of the agency to maintain the slopes,
Lordship.
you have been deploying your machineries and manpower
Yes, Lord.
to clear the debris on the
Yes,
spot.
Lordship.
So now it turns out that one MS Maca Ferry Infrastructure Private Limited is also in the picture
Lordship.
to maintain the slopes.
Yes, Lordship. So unless the McAfee companies implemented as a party, Lordship, we will not know what is the scope of the work, Lordship, because they will be in a better position to explain.
Now, you tell me one thing, this particular landslide in package number 3, this is the first time it is happening?
No, Lordship,
Oh.
it has been there from before.
It is a annual affair.
Not of this serious. Earlier it was there, but
It was there.
it
But
was
not
there,
that
but
serious.
but not
Because of the intense rainfall, Lordship, that has triggered the whole.
In fact, Lordship.
So from what has been submitted by the parties, the solution to the problem is not just clearing the debris.
Yes.
The more you clear, the more it comes down,
Yes, Lordship.
isn't it?
Yes.
Now we have to go to.
So what would be the solution you suggest? There has to be perhaps some proper examination and of the entire area,
Lordship.
My lord, may I intervene here? Sorry for interruption.
survey and all that.
Yes.
My respectful submission, my lord, the issues flagged by this honorable court today, my lord, and why not because my lord, I was expecting the authority engineer and the nodal officer who are the experts to be present today. Unfortunately, they're absent. And we need their expert opinions.
They are not arrayed by name, isn't it?
No, my lord. Lordship, may kindly see the affidavit.
Where are the parties?
Lordship, may kindly see, the affidavit today of the government, one Mr. Ajay Patra.
No, but where's the?
He's a, just refer, which, yes, that one, Lordship.
Yes. Consultant.
Yes, he has filed it, Lordship, and Lordship may kindly see, Lordship may kindly see at page 19, the last page.
He's the
as per-
nodal officer,
So
isn't it?
he's the one.
Hmm. Hmm. This was filed in June.
Yes,
That time there was no landslide.
yes. So my respectful submission is, my lord, the certain queries raised by this honorable court, my lord, to answer those questions, why not a direction will be given to them for their appearance? And my lord, after listening to them, appropriate order can be passed. My respectful submission is, if in view of the urgency of the matter and public importance involved, why not the division bench be constituted on Friday? So that the issues, queries raised by this honorable court, they can come and satisfy this court on Friday. Because, my lord, next week, again, his lordship, KSMA will be sitting here and the matter cannot be taken up. I'm told the landslide started by end of July. And lordship, the state government also should, because, my lord, they have their disaster management department.
Where are the parties? How are they arrayed?
My lord may have a look at the order dated 22/5/2024. In fact, I am for the respondent number 14. I'm also to apprise this honorable court on the development that is taking place in the honorable Supreme Court. So if my lords allow me, I will also apprise the lordships on the
Yes.
brief
Let us-
developments.
Let us just see the
My lord, my
parties
lords,
who have been arrayed.
your lordships.
22/5. Of which year?
24.
22/5/2024. That's the last date on which this matter was listed, your lordships.
No, I wanted to know who are the parties.
So, your lordship, the parties are all
Respondent
there.
numbers 1 to 15.
Yes,
however.
your lordship, it's mentioned
Lordship,
mentioned there in the order.
I'm giving the order so that your lordship will find out, can ascertain the respondents.
This is which order?
Here, there are only 14 parties, and by this order,
10.
the MS Brand Eagle is to be implemented as the respondent number 15.
One is Union of India Ministry, then number 2 is the Secretary. Finance, Union of India. 3 is Chief Secretary. 4 Commissioner, PWD Works and Housing. Chief Engineer, Public Works Department. Managing Director, NHIDCL. And 7 is the General Manager. NHIDCL. 8 is, who is this? MS Ramki? The
My
earlier
lord-
contractor.
My lord, the Rabge was the contractor for 1 and 2.
1 and 2, okay. Then what is this? MSLNMIPP?
That must be the, my lord, authority engineer in the previous work.
Lordship, the PL was for the whole the three packages. That's how different contractors.
Yes.
Then Vertex Company.
Vortex was also a maintenance contractor earlier.
Then T Tachu and Company.
Yes. Maintenance contractor who has constructed the 2 lanes.
MS Chabo.
Yes. Maintenance contractor.
Then 15 comes this Brand Eagles.
Yes. In fact, Your Lordship may kindly direct the registry to maintain a record of the orders passed. So that for ready references,
No, it is here.
maintain a file.
There's a separate file here
Lordship, okay, fine, fine. Lordship,
of the orders passed.
Lordship, yes.
Lordship, as my learned senior counsel has already stated, it's not only the role of the NIGDCL or the contractor's lordship, even the state has got a role to play.
Yes, what kind of role?
Lordship, we have the Department of Disaster Management. So maintain when environmental issues and landslide is there for preventing such kind of a situation, my lord. In fact, the Western Angami Hoho had given a press statement that he had already given warning about this situation quite some time back to the state government and NHIDCL that it is going to happen. That land is unstable and is sliding. But no action was, no preventive measures were taken. That's how we're in this situation.
That place falls under which district?
Kohima,
Kohima.
Under Josuma village.
Josuma village.
Yes.
And do you have a district disaster management?
Yes. Lordship. State, district, we have. Lordship.
District will be the, who's the head chairman, deputy commissioner?
Deputy commissioner. I think,
Yes.
And for the state?
State is headed by. I have to.
My lord. My lord, to divert the water and to stop the quarry and all that, the rule of the state will come into play here. Earlier also, lordship, only because of the intervention by the state, we were able to complete the other 2 projects.
No, district will be DC. This is
Yes.
not a party here.
No.
Then state disaster management.
If the chief secretary is directed, lordship, if the chief secretary is directed, then chief secretary and the deputy commissioner.
No, I just wanted to know who is the the chairman of the state disaster management. Sorry?
I'm not clear. Probably at the level of the secretary.
You should find out. I don't think it's at the level of secretary.
Just commissioner.
Yes. There's a separate author.
State would be the chief minister or the chief secretary.
Most likely a chief minister.
My lord, let him receive instruction and inform the court now.
In
He can make a call and inform us.
Mizoram, it's chief minister. Chief minister is the state disaster management authority.
Here also, I think.
District is the.
You can
deputy
verify.
commissioner.
Let somebody pull up and find out.
The chairman is the chief minister.
Yes, Nish. It is confirmed, lordship.
It's the CM.
So, see, this is not only the construction of work now.
Lordship.
This kind of road blockade for the last 1 week and more.
2 weeks, lordship.
2 weeks. Has to be looked into properly. How many officials have visited the place from the state?
Your lordship here, district administration, they are monitoring every.
Monitoring from where?
No, they used to go to the spot and.
Who has gone to the spot?
No, in Zabza, there is one steel civil minister.
Sorry?
Civil steel.
SDO.
Steel civil.
So why do you leave it at the level of SDO?
Yes.
What will he do?
That is the issue.
No, your lordship here.
See, once the responsible person goes there,
Yes.
everybody follows him.
Your lordship here, there is.
But if SDO goes, nobody will follow him. He will go there alone.
In fact, lordship, with due respect, in the media, it was reported that the highway minister in charge is yet to visit the spot. That was a report in the media. I'm only relating what is reported in the media.
Your Lordship, otherwise, daily there is a monitoring by the administration, and anything may happen. So, Tobaji is there, travel police is there, and district executive force also there to monitoring. But the problem is, it is something like a natural calamity. So
That is the reason.
That's a problem.
That is the reason, because of the gravity of the situation, Lordship. Now the Nagaland, somehow we manage, but what about Manipur, Lordship? 2 weeks. All the drugs are stranded there for 2 weeks. One state is totally cut off for 2 weeks.
So we plead this Mecca ferry as one of the party. Then you have the
authority engineer, Lordship.
Authority engineer.
My Lord,
who is the authority engineer?
NHITSL will be in a position to.
Then the nodal officer also should be implemented.
Yes. My Lord, he was appointed as per the direction of the Honorable Supreme Court. That's how he filed the affidavit, Lordship.
No, we can implement by nomenclature perhaps.
Yes.
Because the person may change from time to
Yes,
time.
Lordship, yes. Yes. Now, that is one aspect of the matter. Secondly, Lordship, taking advantage of this, my Lord, the rock fall at package 1. My Lord, we are traveling there every day, so the 2-lane is already closed, that particular portion. On 4/7/2023, my Lord, 2 persons were killed by rockfall at that particular spot and 3 injured. And on 5/7/2024, my Lord, there was a rockfall. Vehicles were damaged. Unfortunately, there was no injury. It has become a very serious issue, my Lord. It could be defect. It could be because of defective construction.
That falls under
package 1.
Package 1. Okay.
Package 1, my Lord, we call it Bakla Bahar.
Yes.
So, my Lord, blame game is on between the NHITSL and others that on this issue, that the work has not been properly constructed, then proper right of way was not keeping. That's how, in fact, when this issue was raised, the contractor, the Ramge who has constructed the project were raising, when it was under construction, they were raising the issue over and over again that the land given to them, right of way given to them is too small. That's how they are not able to construct proper sloping. That's what that issue was raising, but the NHITSL all along was taking a stand that it is technically viable. So accordingly, since the expert has given a statement before this Honorable Court that is technically viable, that this Honorable Court accepted and the work is completed. But now it is proved otherwise in view of constant rockfall, and that portion cannot be utilized. So, my Lord, on this issue also, my Lord, what remedial steps has to be taken? Proper, either Ramke the contractor has been discharged on completion, but whether he should be revived against them, or what is the standard, what is the steps taken or stand of the NHITSL that, my Lord, also has to be taken into consideration in future.
Yes, who is preparing for NHITSL? You submit.
Also, with regard to package 1, which the Learned Senior Council has pointed out.
That was done by whom?
It was Ramki, Lordship.
Ramki,
Yes,
is not a party here?
Very much a party, Lordship.
They're a party?
Yes, Lordship.
But after completion of the project, my Lord,
Wait. Yes.
you were dropped. After completion of the project, you were discharged.
Lordship, thereafter, we have engaged a contractor for maintenance, Lordship, Innovative Constructions, Lordship, who is not a party in this case, Lordship.
Innovative
Constructions, Lordship.
What are they doing?
Lordship, they have taken the work such as gabion wall construction, base wall construction,
or metal beam crush fairing installations, Lordship. So many works have been done by the.
You travel there once in a,
Lordship. Yes,
once in a while, isn't it?
Lordship.
We also travel that way.
Yes.
Although we're not supposed to say share our personal knowledge in this, but it's very obvious that 4-lane road has become 2-lane road.
Yes.
That 1-lane road towards the cliff, I mean, towards the hillside, it cannot be used. It's full of big, big stones everywhere. And there have been casualties also, as pointed out by Mr. Takamasa. So what remedial steps can be taken for that? That is what we're interested.
Yes, Lordship. On that query, Lordship, as I've pointed out.
It's like constructing a road adjacent to the wall. And the wall can collapse anytime.
Yes.
So that blame game is there. ROW is not there. ROW, despite not being there, clearance was given by the NHIDCL. Court had given the green signal to go ahead. All those have gone now. Now we are facing the consequence.
The new.
So what can be done?
Most of our new agency is already there on the site, Lordship.
But innovative consultant, what will they do? What have they been doing?
Maintenance, Lordship.
How? How will they maintain?
Construction
Putting a
of-
net or something like that is not a solution. Fish net or something like that.
If necessary, it can also be included as necessary party in Lordship.
Who? Innovative
Constructions, Lordship.
Innovative constructions.
Yes, Lordship.
They should be made a party also.
Yes,
definitely, because they should give a report out what kind of work they're doing.
But my lordship, but the buck lies with the initiatives here. They have appointed, but
Definitely.
they're responsible.
Definitely.
And there will be the better person, Lordship, to come in appraise.
No,
before
it's
the
not
sort
that
of
you
work.
appoint somebody and you just forget about it.
Lordship, we are
You're-
monitoring, Lordship.
What kind of monitoring you've done, that also we'll have to know. We'll spell out in the order. We'll have to come up with the answers.
Lordship.
Then what about this particular slope maintenance? You have signed an agreement with Maka Ferry.
Yes, Lordship.
When and how long? And what kind of work are they doing? And where they're not deployed in the site at this kind of
Lordship, we have
time?
appointed them in the month of March this year. Lordship.
March?
Yes,
It's okay. So March is this year. Landslide happened thereafter only.
yes, Lordship. It happened this
So
month, Lordship.
they are not in the picture now anywhere.
Lordship, we have given directions, Lordship.
Which
several
kind of
directions,
slopes
Lordship.
have they maintained? In which part? You are also at a loss.
Yes, Lordship.
What is that?
The action plans, Lordship. My apologies.
Action
Lordship.
plan.
My apologies, Lordship. I have only a copy, Lordship.
What action plan?
Action taken, Lordship. Action taken. And the directions issued to the contractors, Lordship. If I may be allowed to read from the third point, Lordship, the action plan. May I read it, Lordship? A, detailed coordination was carried out at site with district administration and traffic police in progress for clearing of slide from highways was informed to everyone. B, it pertains to Brand Eagle, Lordship, was directed to remove slide from highway and thereafter continuous removal work was undertaken by deploying 4 excavators, 12 numbers of dumpers, 1 numbers of payloader, 1 numbers of JCB at site. Single lane road was open to traffic and balanced slide removal work is continuously being undertaken at site. That pertains to the Brand Eagle, Lordship. And the third, MS McAfee Infrastructure Limited was directed to explore feasibility of diverting the source of water from the slide locations, which was approximately 300 meters away from the ROW and Hills. PVC pipes have been brought to site and channelizing of water away from the site is being undertaken by the new contractor, Lordship. A drone video was also prepared to ascertain the extent of slide. A meeting was attended by DC Kohima and action plan was discussed. This was followed by site visit on 17th of August. DC Kohima discussed ways and means to divert the water channel from the field and directed SDMA, that is the State Disaster Management, Lordship, SDO to look into it. However,
all right.
Lordship.
So these are the action taken by
Lordship. And also the remedial measures have also incorporated here, Lordship.
So let us have a detailed report.
Lordship,
Mr. Takamasa.
I mean,
But what can we
the
do?
action speaks louder than words. So my respectful submission, my lord, since the experts are not, or the principal responsible officer authority are not present today. So and on instruction, they may have difficulties. So my respectful submission, my lord, let the matter be listed again on Friday again, day after tomorrow, and certain direction may be given to them so that on the next day, they come prepared.
No, what kind of direction can be given to them? See, the thing is that they are the one who are at the ground, and
My lord, unless and
they
until,
are in the know-how of the
my lord,
technicalities.
the issue is unless and until at least the nodal officer in the authority engineer president the court, and we will not be in a position to get all the clear picture information about what is actually happening on the ground. That is the concern, lordship.
No, that is why some report has been given here, but this is not.
But the action taken, it is a report
Action
only,
taken.
but what is action, what is actually what is the position on the ground? The authority engineer will be in a position to update us firsthand, lordship. That is a concern.
Of course, they see, we would like this to be in the form of an affidavit also.
Yes.
What they have stated here.
I'll just file.
And
Thereafter, they can file
with-
affidavit.
With supporting documents and all that.
My lord, after Friday, they can file affidavit, but till then, picture will be clear if we, my lord, hear from the nodal officer and the authority engineer on the ground. And also, my lord, the state government to bring instruction from the district disaster management. What step they have been given, government, state government, the council, learned additional AG can bring instruction from the state government about what is actually happening on the ground from the state side. Because the matter has come up for the first time, so my lord, the may not have up-to-date information. Only on public interest I am submitting, lordship.
This has come after, no, this has come earlier also, I think.
My lord, the last time it was listed on 22/5.
22/5.
Yes,
That was the first time after the transfer from the principal.
second time after transfer.
Second time.
But that time, lordship, the landslide, my lord, occurred only from July last.
Now, by the last order, MS Brand Eagles have been made a party.
Yes.
You are the one?
Yes.
Okay. You have filed anything?
Lordship, we are bidding for first time, Lordship.
Okay.
My lord, the MAS Eagle may be directed to file the agreement, the contract on the work order, and what is the progress so far after appointment.
Please write down. Heard Mr.
Your lordships, if I may be allowed to apprise this Honorable Court on the developments.
You are for the?
I'm for the respondent number 14. By the order dated 22/5/2024, I was to apprise this Honorable Court on the latest development in the case
14.
before the Honorable
Who's
Supreme
14?
Court. Chabu and Koi, lordship. So, my lord.
No,
I-
what
yes,
is
your lordship.
14? What is the
14.
role
He
of
was,
14?
he was the M&R contractor engaged, and by order dated 31/3/2023, this Honorable Court directed the NHIDCL to award the work to MS Chabu and Co. Lordship, a joint venture, because of the satisfactory work that we performed.
Okay, okay.
Yes, your lordship. After that,
But the Supreme Court has set aside that.
that is why, your lordship, I'm coming to that. So the NHIDCL went to the Honorable Supreme Court. While the matter was before the Honorable Supreme Court, the NIT was to be floated. Then the bid documents, they were irreconcilable as well as irreparable, the shortcomings in the bid papers of the respondent number 15. So, your lordship, we questioned all those, and we even questioned the practice of cartelization by the NHIDCL. Now, my lord, when the matter was heard on 15/4/2024, on that date, unfortunately, your lordship, the council representing the respondent number 14 could not be present that day. And without hearing us, your lordship, the appeal was allowed and the work was awarded to respondent number 15. So, my lord, we have filed a petition for recall of the order dated 15/4/2024. My lord, before the Honorable Supreme Court, the matter was heard on 23rd of August this month, your lordship. But your lordship, the two judges, one of the judges who passed the order was in the same bench, but the other judge was absent. So your lordship is again fixed on 3rd of September 2024. And my lord, I will apprise the lordships on the development. We have questioned the action of the NHIDCL as well as the engagement of, we have questioned the competency of.
Initially, we're engaged.
As
but
MNR
then-
contractor, MNR maintenance and repair contractor.
Correct. But since your performance was very good,
Yes.
so they awarded you the work.
They
for
are-
this,
This honorable court
for this-
directed the NHIDCL to award us the work.
Package 3.
Yes, your lordship, package 3.
And that has been set aside by the Supreme Court.
Yes, your lordship.
And pursuant to that, 15, respondent number 15 has been appointed.
Yes, your lordship.
And they are doing the work now.
Yeah, yes, your lordship.
And
So
where are you now?
now we are asking that order to be recalled, the 15/4/2024.
You file a review.
We have filed a miscellaneous application to recall that order.
On what ground?
Your lordship, that is before the honorable Supreme Court.
No, on what ground?
No, on the
It's
ground
a
that,
top secret order.
yes, your lordship, there were clear discrepancies, irreparable discrepancies
In?
and incompetence of the present respondent number 15
Hmm.
and the nature in which the work was awarded to them, your lordship. Those are being questioned.
But there's no stay as such, isn't it?
As of now, yes, your
There's
lordship.
no stay. It's
Yes,
only-
your lordship.
Hmm.
No stay as such. But after, since it is listed on 3rd of September,
Hmm.
I may be allowed to apprise this honorable court on the next date on the development, my lord.
Surely, sure.
And even the maintenance and repair contract
Hmm.
that has been performed by the respondent number 14, my client, that is also yet to be closed, your lordship. There's been no closure, your lordship, as far as our engagement is concerned.
Maintenance.
Yes, your lordship.
Of which area?
The package 3, your lordship.
Package 3. You're still engaged for maintenance?
It cannot be said we are still engaged, but there is no closure, your lordship. It's just that there has been no direction from NHIDCL for us to
Was there
continue.
any term for that?
It's yet to be closed, your lordship.
Any tenure for that? Your maintenance was for how many? What was the duration for the period?
Your lordship,
the time.
that I have to ask my client, your lordship, but there's been no official closure. But if we were directed, we wanted to help the people of the state, your lordship. In fact, not just one state, 2 states. We were even ready to help at this point of time, your lordship.
Lordship, on this issue, in fact, the NHIDCL is yet to give me a copy of the agreement or the work order. So the other day, I was questioning, inquiring from a learned friend, whether the scope of work of the present contract is for the whole four lanes or just 2?
Including, that is 4 lane, but also the existing.
Because lordship,
Should come.
because the issue is this, my lord, the 2 lane which was constructed by the maintenance contractor, my lord, now it is, we are traveling there, it is now in deplorable situation. So, my lord, that priority should be given so that the road is properly maintained.
By us.
Without that, my lord, because we are waiting for all the project to be completed, my lord, we are suffering. So the 2 lanes, the present which we are applying, should be properly maintained. That direction also is required, lordship, if it is part of the scope of work.
Okay.
But as the instruction I have received,
Hmm.
with regard to the respondent number 14,
Hmm.
I'm instructed that they have refused to sign the agreement for close the agreement.
Okay.
Perhaps it's because of the development in the honorable Supreme Court, your lordship. My lord.
Okay. So we'll have it again on Friday?
Yes.
You ask the authority engineer to come and the
Nodal officer,
Nodal
lordship.
officer. That, yes, and HRDCL can take care of that, isn't it?
Yes.
Who's the authority engineer as of now?
A new agency has been appointed.
Okay.
Lordship. I have to get this.
Oh. You should come with the details. Who has been appointed?
Lordship.
My respectful submission, my lord, if the NHIDCL can, council can obtain the instruction and give the particulars to your lordship within the course of the day and be implemented by today itself.
That's why I can do that.
All right. I heard Mr. Takamasa, Lanet's senior counsel and amicus curiae in the matter.
Okay.
Also heard Mr. Moa Jamir, learned counsel for the NHIDCL.
1, 2, 7, 6, and 7. 1, 2, 6, and 7.
It's mine.
Respondent numbers 1, 2, 6, and 7. Then Mr. N. Mozui, learned counsel for respondent number 15. And Mr. Joshua Sheki, learned counsel for the respondent number 14. And
For me-
Mr. Imti
My interest is
Imsong, learned additional AG for respondent numbers 3, 4, and 5.
You're doing well.
Anybody left out?
And then if you do, I'll also go out of the way to support you.
This is a
Maybe you work.
moto
That's
PIL
what I
taken
do
up
for
by
the
this
other
court
contractors.
in view of certain issues which has cropped up in the construction of the 4-lane road, is it?
Yes.
Yes, for it.
4-lane road, Dimapur to Kohima, falling under National Highway 29. Stop. In terms of the last court's order dated 22/5/2024, the respondent number 15 has entered appearance through Mr. N. Mozui, who submits that he may be given some time to file an affidavit incorporating all the relevant materials, including their agreement signed between signed with the NHIDCL.
Includes the work order also.
And also the work order. Stop. Next para, the issue which has drawn attention of this court at the moment is with the landslide which has occurred in chainage 164 under package Roman 3.
Lordship, may I kindly give the area name? Zizda.
In Zudza, is it?
Zizda.
DZU, DZA.
Yes.
Zudza. Which has resulted in the complete blockade of the NH 29, requiring all vehicles, to, no, not required, blockade, complete blockage of so-and-so.
For the last 2 weeks, Lordship.
For the last 2 weeks. Mr. N. Mozui, learned counsel for respondent number 15, submits that under the instructions of the NHIDCL, the respondent number 15 has
Because machineries and power.
deployed machineries and manpower in and around the landslide area to clear the blockage. Stop. However, due to the incessant rain and the recurring what do you call that? Mudslide. Recurring mudslide. The blockage could not be cleared till now. To stop, he submits that respondent number 15 has come to learn that for maintenance of the slopes, the NHIDCL has assigned the work to 1M/S Makka Ferry Infrastructure Private Limited. You take this, huh? And therefore, the said company would be required to undertake the work for which it has been engaged. Next para, Mr. Takamasa, learned amicus curiae, submits that as directed by the Supreme Court, White order dated 15/4/2024, the NHRDCL was required to appoint a nodal officer to ensure proper and timely completion of the entire work. Stop. The nodal officer has not been specifically implemented, and that an affidavit has been filed by the respondent number 7, bracket NHIDCL, apparently sworn by the nodal office, appointed nodal officer, stating that the NHIDCL is making its best efforts to have the project completed within the given time frame, that is by end of September 2025. The learned senior counsel, learned amicus curiae submits that the nodal officer should be implemented as a party respondent, and also the newly appointed authority engineer, so as to enable the court appreciate the actual development of the work. Stop. The learned amicus curiae further submits that not only is the contractor concerned and the NHIDCL responsible for the proper and timely completion of the work, but in view of the heavy landslide which has occurred in recent times, and which is also a common feature, the state government would also be responsible and answerable for making the NH-29 pliable. Throughout all seasons. To stop, the learned amicus curiae has also expressed concern about the falling of rocks falling under package number 1 in an area which is called, within inverted comma, Pagla Pahar. Close inverted comma. Stop. He submits that in recent times, due to heavy rock fall in the said area, there has been fatal casualties and also damages to vehicles flying through that, passing through that stretch. To stop, he submits that due to the falling of the rocks, the 4-lane road has been made into a 2-lane road only. Since the road which is adjacent to the, towards the hill is unusable because of the falling rocks. To stop, he therefore submits that the who's looking after this innovative constructions in it?
Package 1, Lordship.
Package 1.
Yes, Lordship.
That area falls under package 1.
Yes, Lordship.
He submits that as per the information received, the maintenance of the road has been given to one company called MS Innovative Constructions. We give the full address. And therefore, the said company should also be made a party to this case, so as to enable the court get first-hand information about the works undertaken, maintenance work undertaken.
At package 1, Bagala, Bahar Lordship, can you make it specific?
Did I say package 1? No. The learned counsel submits that the Pakla Pahar area falls under package number 1. Next para, the learned additional advocate general submits that insofar as the landslide which has occurred in and around Zutza, falling under chainage 164, the district administration and the local authorities have been visiting the place and taking stock of the situation, while requesting the, while directing the construction company to spare no efforts to clear the road. Next para, Mr. Joshua Sheki, learned counsel for respondent number 14, submits that pursuant to the order passed by the Supreme Court on 15/4/2024, the respondent number 15 has been appointed as the works contractor. But there are certain irregularities in making the selection and appointment of respondent number 15, and for which the respondent number 14 has approached the Supreme Court for recalling the order dated 15/4/2024. Stop. He submits that the same is due to be listed again on 3/9/2024, and that he may be allowed to apprise the court about the developments of the case.
Lordship, may I submit that a line may be added regarding the concern, my concern shown for urgent construction of drainage to divert the water from the top flow of water, which is should be taken up by the state, NHIDCL as well as the state.
Then you write somewhere in the where Mr. Takamasa had submitted, okay? Mr. Takamasa, learned amicus curiae, further submits that it is not only the clearance of the earth which has blocked the road that is the concern, but also the diversion of the flow of water from the hilltop, which has caused the recurring landslide in the said area. He submits that the same should be looked into by the NHIDCL as well as the state government.
Yes, Lordship.
So that a durable and permanent solution can be arrived at. Then continue with the next para. In view of above, we deem it appropriate to implement the nodal officer appointed by the NHIDCL in terms of the Apex Code direction dated 15/4/2024, the newly appointed authority engineer appointed by the NHIDCL and MS Innovative Construction Private Limited, perhaps give it the address as.
And make a free also, Lordship.
Okay, then not and, okay, just put comma again after new Innovative Constructions Private Limited and MS Macaf Ferry Infrastructure Private Limited as party respondents to the present proceedings. Stop. They shall be placed at they shall be implemented as respondent numbers 16, 17, 18, and 19 respectively.
Lordship, the NHIDCL may be kindly directed to communicate, inform the respondents, because you must be in contact with them all on all occasions.
They can no doubt inform, but shouldn't there be a formal notice or something?
Formal notice as well as personal information, Lordship, both. Because by Friday, Lordship, just by email, they may not.
Mr. Moa Jamir, learned counsel for the NHIDCL, shall provide the proper address of the newly implemented respondents. And the registry shall prepare a fresh cost title indicating all the parties arrayed as on today. Then next para, issue notice to the newly impleted respondents. Returnable by 2 weeks.
Lordship.
Registry shall send notice to the newly impleted respondents by registered post with AD due, as well as through email, and the address of which should be provided by the learned counsel appearing for the NHIDC. Mr. Mo Jamil, learned counsel for the NHIDCL, is further requested to inform the nodal officer and the new authority engineer about this order. And the desire of this court for their presence on the next court date. Presence in person on the next court date to assist the court. List the matter again on Friday would be 30th, isn't it? 38/2024.
Lordship, an order was passed earlier to provide a copy of the order to me, Lordship, on all occasions. So I pray that
this order.
Yes, all the orders passed so that to enable me to assist the court. This is a standing order, so I'm praying that it may be reiterated, that orders passed today and subsequent thereafter to be provided to me, a copy of the order passed.
A copy of the order, a copy of this order be a copy of this order and any other orders that may be passed subsequently should be made available to Mr. Takamasa, learned amicus curiae, to enable him to, in order to enable him to assist this court.
Lordship.
Friday we'll have it. We'll just come up with the engineers. We'll see what can be done. Lordship. This is not adversarial. We want things
Yes.
to work out.
Yes, Lordship.
For the betterment of this area, because
Lordship, yes.
unless we do something, then it's going to be defeat. Yes. Oh. We'll just rise for 5 minutes and come back. Yes. Back.
Next week, really ভাল আছিলে এৰালো চুৰিলো এনেকুৱা কথা কৈ আছে 2 weeks marks though. After the second half also karena aku cuma aku bilang kita That's a pretty much what's happened up now speaker right Yeah. কথা হাল্লা কৰিব কত Magin is a chance.
For admission, item number 2.
Yes.
May I place your lordships?
Yes.
This is a matter where the temporary officiating charge to the post of secretary, Nagaland Legislative Assembly has been challenged. Now,
somebody has been given temporary
yes,
charge.
temporary.
You're challenging that?
Yes, temporary charge. So I may be allowed to cite the brief background before I refer to the relevant documents, lordship.
Yes.
That will be more easy to comprehend with the facts of the case. In 1996, there was a recruitment. I am the appellant and the writ petitioner also. I have been appointed as Assistant Research Officer in the Nagaland Legislative Assembly Service. And by the same advertisement, the private respondent number 1, that is who is the present private respondent who is holding the charge of secretary now. She has also been appointed as Assistant Transport Officer. Now, incidentally, I have been placed in a general cadre where the promotional post is up to the secretary as per the service rule. The first service rule was in 2000, Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rules. That was 2000. And thereafter in 2005, it was amended, first amendment. Second amendment was done in 2015. And the third amendment has been done in 2022. Now, the private respondent, she was appointed as Assistant Transport Officer. But then from time to time, it so happened that she was placed in a different cadre where there was no promotional avenues to the higher post. Therefore, the post held by her has been upgraded from time to time, personal to the incumbent. Whereas my promotion from time to time was in the general cadre, and my pinnacle's position will be the secretary in the assembly. But since the private respondent was placed outside the general cadre, the post held by her has been given upgraded personal to the incumbent to the transport officer, senior transport officer, joint secretary, like that, up to the additional secretary transport. That was done in the year 2021. Now, incidentally, put the promotions, my promotions and her upgradations were on the same date.
To the post of additional.
Two different posts. When I'm promoted to the next higher post, on the same date, the private respondent is also upgraded the post and promoted to that upgraded post personal to the incumbent. In short, she was outside the cadre, but step-by-step promotion was simultaneously done.
Same date.
Yes. So a presumption was taken that we are equal, although she was outside the cadre. One interesting development that took place was on the 1st of November 2021. After attending the stage of additional secretary, the private respondent was brought to the general cadre, assumed to be brought to the general cadre. A notification was issued by the speaker granting her to come to the general cadre. It was made equivalent and transferable. Therefore, that was challenged by 4 individuals.
What was that designation, if I may interrupt you? In the post of additional
Secretary Transport.
Transport.
Yes.
And in your case?
Additional secretary.
That's all.
That's all. Because I'm in the general cadre, she was outside the cadre. But the person who was appointed in the outside the cadre has been brought to the general cadre and allowed to hold the post of secretary, not the transport. Therefore, that was challenged by 4 individuals by filing a writ petition. And this honorable court
In fact, the lordship said.
Lordship has quashed and set aside the order that
Bringing in
1st November, bringing to the cadre.
Bringing in of somebody who is not from the cadre.
Yes.
As secretary.
Yes.
I see. There's no provision in the rules.
No provision. Okay. That is why this honorable court was placed to quash. But in that order was passed on 12th May 2022. 12th May 2022. However, an observation was made by this honorable court to the effect that after quashing the notification, everything, however, if the respondents want to do the cadre review, restructure, and the cadre review is done, that may be done, liberty is given, but that can be done in accordance with law, in accordance with the provisions of law, and with due consultation with all the stakeholders. That observation was made.
Okay.
So 2 things. It has to be done if the cadre review wants to do, liberty was given. 2 conditions. One is in accordance with law. 2, by taking into consideration of all the stakeholders. So 2 conditions were given. Taking advantage of that observation, within 6 days, on 18th of May 2022, the speaker has amended the rules. And in the amended rules, the additional secretary transport was made transferable with the general cadre. And general cadre can also go there. Such a provision was made above the joint secretary. And up to the joint secretary, no transferability of the post, but above joint secretary, there can be transferability of post. Above the joint secretary level, there are 3 categories of post. One is additional secretary, that is general cadre. Additional secretary transport, that is the post held by the private respondent. And OST to speaker, that is the stenograde. They will be recruited as a stenographer, junior stenographer, and then they will be upgraded. The Benegals post position is OST to the speaker. So Estino was also made eligible to bring interchangeable as additional secretary. So it is their prerogative, so they have done it. Whether it is reasonable or not, I am not questioning that. And they have the power to do that also, provided it is done in accordance with law. So on 18th of May, 2022, rule was amended. And it was made transferable above the joint secretary. So they are saying, the respondents are saying that by this amendment, I have become eligible to hold the post of secretary, since the posts are transferable. And that notification was issued. Amendment was done by way of filing affidavit by the state respondent, the speaker. And a categorical stand was taken that this amendment has been done in terms of the order passed by this honorable court on 12th May 2022.
Now, in which case? Somebody had challenged that.
In another case where the encadrement was challenged,
Who's the petitioner?
there were 4 petitioners, street petitioners. They have challenged, and that was quashed. But then observation was made that, however, if the respondents want to restructure the cadre, they can do it.
That I've understood. But subsequent to that, you said some affidavit was filed. In which case?
That affidavit was in the subsequent case. Writ petition was, yes.
Filed by whom?
Yes. Before I come to the other stage, I have mentioned about this affidavit.
Yes, yes.
That's why what Lordship is putting is correct. Let me come to that.
Okay.
This amendment was challenged by the present appellant.
Okay.
No. Association, Nagaland Assembly, Legislative Assembly Secretariat Association, and the 3 individuals who are affected. 4 petitioners have challenged the amendment. That is registered and numbered as WPC number 92 of 2022.
Okay.
So in that writ petition, the question raised and the challenge was made on 3 grounds. Basically, number 1, look, this honorable court, while disposing of the earlier writ petition, has made an observation to liberty was given to restructure. If it all it is necessary, you do it, but you do it in accordance with law. That is first condition. Second condition is to, by taking into consideration of all the stakeholders. That was not done. And it was not done in accordance with law, and the stakeholders were not consulted at all. Therefore, the writ petition was filed that, look, this amendment has been done so as to circumvent the court order. Indirectly, you are trying to nullify the court order, and without consulting the stakeholders, you have amended the service rule. An amendment was done within a period of 6 days. By filing affidavit, I'm coming to the point, Lordship.
Yes.
By filing affidavit, they have stated that this amendment has been done pursuant to the order passed by this honorable court on 12th May 2022.
Okay.
So, in reply.
WPC 92.
Yes, in WPC 92.
Still pending? 92.
Dismiss. That is dismiss. I'll come to that.
Dismiss?
Yes, dismiss. Now.
So it's against that you've come?
No. This is different. I'll just complete. Let me just complete. Now, if you have amended the service rule pursuant to the judgment passed by this honorable court, the date of judgment was 12/5/2022. Amendment of the rule was notified on 18th of May 2022. Within 6 days' time, they have amended the service rule. And a categorical stand was taken by the speaker that this amendment has been done pursuant to the order passed by this honorable court. Therefore, we put the question that, look, going by the records, we have enclosed in our reply. Speaker has approved the file for amendment of the service rule on 16th May. No, 8 on 10, I think. Yes, on 10th of May.
Judgment passed by this honorable court was 12/5/2022.
So before judgment, he had approved.
Before judgment was delivered, he has approved the file on 10th May 2022. Therefore, how can you say that this has been done pursuant to the order passed by this honorable court? That is highly questionable. We have enclosed that approval of the speaker. The court was also called for by this honorable court in WPC 92. However, I have no grievance, but then the observation was that there was no finding on this point at all. This was our categorical contention, specific. No observation was made on this. But since we have not challenged this WPC, the judgment which was passed on in WPC 92,
I'm sorry, 92.
we have not challenged that.
What is the date of judgment?
Now, there are, Lordship, before that, it was kept CAV on 3/2/2023. CAV. Because there is some relevance here. That's why I'm referring.
May I please,
CAV was on 3/2/2023 and judgment was pronounced on 24/4/2024. It took long, 1 year, more than 2 months.
May I please, Your Lordship.
I'm making submission, I have
I'm
not
on the
completed,
merit,
Lordship.
just to intervene.
If I'm wrong
With
and
the-
if
not
I'm
on
making
merit,
an
not on
incorrect
merit.
submission,
Not on merit.
then my
Lordship.
learned friend can also
Not on
interfere.
merit, Lordship. Not on merit.
No, no,
My
I'm
only
submitting,
concern is
Lord.
this. Not on
I'm
merit.
submitting.
I'm not commenting anything on merit. Just
Let me
with the leave of
complete.
my learned friend. My lord, this matter will take more than 1 day. Today, it is 1 o'clock. It cannot be completed today. If we have division bench tomorrow, day after, the matter will be continued. Otherwise, since this honorable court is still this week only, whether it will be wise to keep part third. If lordship is willing to constitute division bench tomorrow, day after, fine. Otherwise, 2 hours from now, we may not be able to conclude. That is the only concern. Otherwise, I have no objection on the merit. I'm sorry for intervention, but.
So let me
concern
submit,
should-
let me submit. Now, it was kept CAV on 3/2/2023.
This WPC 92.
Yes, judgment was pronounced on 24/4/2024.
Okay.
And just, I'll take 2 minutes how the judgment was passed, but then since I have not challenged this, in that writ petition, as I have mentioned other points, those points are there. And 2 additional points which we have taken was, there was one Anthony who was holding the charge of commissioner and secretary. He was appointed after retirement from Lok Sabha. So we also taken a ground that look, the retirement in Nagaland, the public service, retirement from Public Service Employment Act, a person cannot work beyond 60 years. 35 years, 60 years, whichever is earlier. He has already retired from Lok Sabha. Therefore, he is over age to get any employment under the state. That was also one of the grounds we have taken in WPC 92. Because at that point of time, one Anthony was there. There was a lot of agitation by the members of the Assembly Secretariat employees.
You were also a petitioner in 92.
I'm the petitioner, yes.
You are the petitioner in 92.
Yes, yes.
Along with the
Association.
association
Yes.
and three
Yes.
aggrieved
Yes,
persons.
exactly, Lordship. But in view of the agitation, the commissioner and secretary, one Anthony, he has resigned and left.
Okay.
So one part of our claim was again resolved by that. And in that agitation, hopefully all the employees were united together. That is one. Another point, there was a gather review committee appointed by the speaker earlier, before the judgment. It was in the process going on. But without taking into consideration of all this ongoing process, the speaker within 6 days' time, rule was amended. So we raised a complaint saying that, look, if it is to be done in accordance with law, there is a gather review committee constituted by you. Why not you take the report from there and amend the rules? We will have no grievance. That is one point we have taken. But ultimately, how it was decided, the Nagaland Retirement from Public Employment Act, initially it was in 1991.
that was already quashed in 1993 by this honorable court. But relying on the already the redundant law, basing on that judgment was given, but admittedly we have not challenged. Why it is not challenged, that is another aspect. But judgment was rendered by relying on the already quashed provision. Judgment was passed, number one. Number two, if the amendment was done pursuant to the order passed by this court on 12th May 2022, and the notification was issued by amending the rule was on 18 May 2022, the speaker has already approved for amendment on 10th of May 2022. What is this? Putting the cart before the horse. That was the plea taken, but that is not observed in the judgment at all. But since we have not challenged, judgment is there. And another very important point, which the Honorable Court has gone wrong in, that is, the court was of the opinion that we are questioning the legislative competence of the speaker. We have never questioned his power. He has the power to do it. But the only grievance raised in the WPC 92 was, look, the observation made by this honorable court is two. One, accordance with law, and by taking into consideration of all the stakeholders. This was not done. That was the point we have raised. Not that speaker do not have the power to amend the rule, all this. But all the finding was as if we have challenged the competence of the speaker to amend the rule, that you do not have the.
See,
not at all.
Mr. Jamir, you say that you have not challenged the judgment.
Yes.
But why are you referring to that?
Yes, that's why. That is very relevant.
This appeal is against what?
Yes.
Which judgment?
Appeal is against an interim order in another writ petition. They are saying that it is already covered in view of dismissal of the WPC 92. It is not. Why? How this present writ petition came to be filed, Lordship. When this WPC 92 of 2022 was pending, on 5th of July 2022, the speaker has delegated the power to the respondent number one, who was only about 2 months in the rank of additional secretary. But as per the rule, in order to promote to the post of secretary, there should be 2 years continuous service in the grade of additional secretary. But without fulfilling that, within a period of 2 months, she was given temporary officiating promotion to the post of secretary. This 5th July 2022 notification is with two conditions. Number one condition, this officiating promotion is subject to the final outcome of the case in this WPC 92 of 2022. One. Two, the incumbent will hold the charge till a regular secretary is assumed, till a regular secretary assume charge. Two conditions. Now, on 24th April 2024, writ petition was dismissed. Then there is nothing left for the speaker to, nothing stopped the speaker to fill up the post on regular basis. Who should be considered for the post of secretary? That should be decided. Till date, they have not decided. So my suspicion goes that, look, had the speaker take initiative to fill up the post of secretary in accordance with law, the private respondent number one has not completed even 2 years. So till date, they have not taken any steps for filling up the post of secretary on regular basis, whereas within 6 days' time, they have amended the service law.
So
Two
it
years, 2
is
years of service,
apparent.
2 years of service as additional secretary
Yes.
is
Rule
required
7, clause P,
under the amended rules,
under the old rules.
old rules. What about that amendment?
This was not amended.
It remains.
Yes.
Okay.
Now, the officiating promotion was given basing on Rule 18 of the rules. And Rule 18 was not amended by the new amendment rules. Rule 18,
Okay.
which says,
2 years.
which allows the speaker to assign the functions and duties of the Secretary of Nagaland Legislative Assembly to any of the senior most. So, on the day of issuing the promotion order, officiating promotion order on 5th July 2022, the private respondent who was holding an ex-cadet post and by the new amended rules above joint secretary with effect from 18th of May 2022, it was made interchangeable. So let us assume that she can come to the general cadre. But by that time, she was only having a length of 2 months only in the rank of additional secretary. So, but I'm the additional secretary since 2019. Therefore, I filed a writ petition questioning the officiating promotion of the private respondent number 1.
What is the writ petition number?
Writ petition number is writ petition number 144 of 2022.
Is it still pending?
Yes.
Still pending?
Yes.
And then by this.
No. Writ petition is pending, but this appeal is against the interim, vacation of interim order.
Interim order.
Yes, interim order, Lordship will find at page what? 122. But instead of going into all this, I would like to refer to the relevant paragraph, that is 11.2. The operative portion of the order, because it is little lengthy. I don't want to.
Interim order is passed in the IA.
Yes.
116.
Yes.
And the order is dated 12/8.
Interim order, initially it was passed on 22/7/2022 in my favor.
No, your challenge to.
I have challenged, that is.
Vacation of the interim order.
Yes.
12/8/2022.
That is 12/8/2022.
On what grounds?
There are many grounds, but before that, Lordship may kindly come to one paragraph so that it will make complete with the other case.
Paragraph number?
Paragraph page 129. I'm taking to the first interim order which was passed because interim order was vacated on 2-3 grounds. Number 1, we have suppressed the facts. Which fact was suppressed, they have to show. They should show. They could not show. Rather, it is they who has suppressed. Number 1. Number 2, the learned single judge came to a finding that relevant provisions were not taken into consideration. Which relevant provision was there in that case, they should be able to show. Now, relevant provision in the writ petition was only Rule 18 because the speaker has given the officiating promotion by exercising power, by invoking power under Rule 18 of the rules. So what Rule 18 says will be very important. And this was the sole issue because the issue in this 144 is purely with regard to temporary officiating promotion of the private respondent. Nothing else. Nothing more than that. But that should have been given to the senior most officer. I am the additional secretary since 2019. By ignoring me, why a person who do not possess the eligibility criteria has been given the current charge.
But you were saying that both of you were promoted on the same
No,
day.
no. That is on the basis of the new amended rules after the order is passed by this honorable court. And our promotion on the same date was, I was in the general cadre, which is fit to be considered for promotion to the post of secretary. Her post was upgraded personal to the incumbent. That is the reason why nobody could hold the post held by the private respondent. But in my post vacated by me, so many officers were promoted to the post of under secretary, deputy secretary, joint secretary, all that.
No, no.
But
I understand. Thing is that you were saying that you're senior because she has been holding the post only for 2 months, you said. And you were there
after
since
the
2000.
amendment was on 18 May 2022. Promotion was on 5th of July 2022.
Promotion to
Secretary.
secretary.
Yes. So if the role has made eligible for the private respondent to occupy the post of secretary, to consider her promotion, it will require 2 years. And that is what they are waiting now, to complete her 2 years so that she'll be eligible and she's the better one. That is the game plan of the speaker.
Okay, we come back. Like Mr. Takamasa expressed his concern. What do you say? Can we?
Lord Chief, I will take only 30 to 40 minutes and I will complete because it is not complicated. If I'm to refer to all the irrelevant things, I can take 3 days. But what is the point? Even if I go to the irrelevant issues, Lord Chiefs can stop me. My learned friend should also know that.
I should be given sufficient opportunity because I'm facing the music. He wants to go away with my current judge.
We are supposed to be comprehended with the different provisions of law.
It is not
So it
officially
is not
promoted.
necessary to take time. And if I submit irrelevant things, Lord Chiefs can interfere. Stop me. No,
No,
this is
see-
irrelevant because of this and that reason.
Thing is, you see, this bench is available till Saturday. And normally we have division benches only in.
I will not
Wednesday.
take even 1 hour, Lord Chief, in the second half. Then, and I'm the appellant. I'm the petitioner and I'm the
I'm
appellant.
supposed to reply. My learned friend is also
I'm not saying that
the
you should not reply, but
So
I'm the petitioner and
No.
I'm the appellant and I'm the aggrieved person.
my respectful submission.
My learned friend's client is only the
My-
beneficiary.
No, my humble submission, Lordship. On previous occasions, on last 2 occasions, when the matter was listed, last 3 occasions, my learned friend was absent. That's how the matter is listed today. We were present on all the last 3 occasions. And even after granting of last chance, my learned friend was out. Anyway, that's a different issue. My only issue is, my
By
lord,
saying that, what do you
if-
mean to say?
my lord, if tomorrow or day after, if this honorable court desires, is in a position to consider division bench, then we can take up. But in my reciprocal submission, definitely I'll take more than an hour. Because I have referred to the judgments in all the facts has to be clarified. So definitely, my lord, minimum 2 hours or 1 hour, I will require.
We have still 2 days, Lordships.
So it's up to
And
the
the Lordship
If
has
Lordship is willing to
constituted.
That's why I'm saying, I have no problem if this honorable court is willing to. consider
Virtually,
division
I have
bench,
already summarized the
problem.
facts.
I have no problem for that.
So I'll
But then-
I'll not take even 1
But
hour.
then, when
In
we
the
go
second
deep
half.
inside, when you go delve inside the issues, definitely, my lord.
No,
there are
see,
issues.
What is there to go into deep? It is
No,
about
no.
interpretation of Rule
He
18.
wants to terminate my service.
Impugned order was issued on basing on Rule 18. So what Rule 18 says, that will be relevant.
anyway, see, basic thing is that both of you are on your own respective cases, but what this court is expressing is that is it possible to complete this matter
Yes, Lordship.
within the given time?
My response to that,
And,
it can
and
be.
of course, if we exclusively give the entire time for this, we can complete, but there are other matters also.
We have, in the second half, we have more than 2 hours, Lordship. I'll not take even 1 hour.
There's one matter also, yesterday's matter, single bench today.
I'll not take even 1 hour
That is the
in the
constraint.
second half. Since I have already submitted the background. Only to the relevant where I'm agreed, I'll go to that. And I do not have so many citations like my learned friend because it is a very simple fact. Irrelevant things I will not bring.
My lord, it is his own risk. If you want to make a short submission, that's up to him.
That's why I'm
But I should be
making
giving
that
sufficient time.
undertaking. I'm
He
making
cannot-
that undertaking.
He cannot impose on me how much to submit.
Okay. Okay, we'll come back at 2 then.
Lordship. Roll it in the view, it's has still be, you know, be the way. There.
Kaya.
Excuse to.
I beg your lordship, dominion item 17, hearing.
17. Yes.
This is a tax matter, however, lordship, in view of other admission hearing matters, this matter is not likely to reach. So may I bid that this matter will listed next week, lordship, on 4th.
No objection.
Wati Jamir,
lordship.
as paid for by Mr. Wati Jamir, learned counsel for the appeal. This is the matter again. For hearing in the next week.
4/8. 4/8.
On 4/8. On 4/8.
Lordship.
No,
4/9.
4/9.
4/9, 2024.
Sorry. Objection.
Yes.
Much over.
May I please, Lordship?
Yes.
Lordship, I beg to mention item 8. In the morning, mention our your Lordship. Prayers mention has been made on behalf of additional AG for adjournment, your Lordship.
Yes.
However, I prayed for taking up the matter as per the list, but I don't think it will reach, your Lordship. Here, I have no objection to the adjournment sought, your Lordship. But here I have a prayer, your Lordship. Now, your Lordship, the matter relates to alignment of road, and the petitioner, by filing this PL, is questioning the decision-making process of the respondent authorities in recommending the road alignment in respect of national highway starting from Shohuba to Pangsha, your Lordship. Now, in the meantime, petitioner has come to know from reliable source that the road alignment has been changed. If that be so, your Lordship, nothing survives in this petition. So the petitioner has filed an RTI application to NHIDCL for response number 5 to 7, Lordship. Now, since NHIDCL is already represented, your Lordship, on the next date, if NHIDCL may come with this thing, whether road alignment has been changed. If it is changed, nothing survives in this, your Lordship. So if the NHIDCL may be instructed to bring necessary instruction.
Who's
your
for them?
Lordship.
You're there.
Lordship, I'm for the NHIDCL.
Yes. What is the instruction?
On the next date fix, your Lordship, if instruction may
NHIDCL's response number?
5 to 7.
Lordship, in that case, I'll take instruction from the NHIDCL and present next day.
What is the PL regarding?
This is the thing that what I'm seeking for instruction. Number one, complete alignment details with changes from Mukalimi to Agunato, or both option 1 and option 2 under section 3 of Showa to Pangsha.
No, PIL is filed for what purpose?
PL, I'm questioning the decision-making process in recommending the option for the road alignment in respect of section 3, your Lordship. Now, I've been informed that this alignment, which has been recommended, is already changed. So,
Okay. Please write down. Mr. T.B. Jamir, learned counsel for the petitioner, submits that PIL has been filed questioning the decision taken by the authorities concerned for alignment of the road under section 3 of Shohuba dash Pangsha East dash West Corridor Road. Stop. He submits that in the meantime, it appears that the alignment of the road has been changed. And if that is the case, the PIL may not survive. Stop. He, however, submits that he does not have any confirmation regarding the information given to him. Come on. Stop. In view of above,
I've also filed RT application.
there's no reply.
No, there's no reply. I have filed this on 19th, seeking information from NHRDCL.
Then in view of above, we cancel that, okay? He submits that the petitioner has also filed an RTI application seeking information in this regard, but till date, there's no information. Public reply. Next para in view of above. Learned, your good name?
Akrivchasi.
Have you got it? No, just say again. I want to pronounce.
Akrivchasi.
Akrim.
Yes, my lord.
Akrim Chisi. Mr. Akrim Chisi, learned counsel, appearing for the respondent and HIDCL, submits that he may be given some time to obtain instructions in this regard. In view of above, how much time?
1 week time will be enough.
A week's time is granted to get instructions. List the matter again after a week.
Oblige.
If Lordship, you kindly give us a date. I'm for respondent number 8.
Okay, date. This is DB matter, isn't it? So
Lordship.
1 week would fall again on 4th of
My lord,
September.
my lord,
Lordship.
case Eba cannot take up this matter.
Oh.
So thereafter,
Then how long, when can we have this?
is as per the, my lord,
We can try on 11th, your lordship.
yes, we can attend the
11th.
Yes, lordship. If it is then the matter automatically cannot,
Okay.
we can try on 11th, lordship.
Before, list again after, on 11th.
Lordship.
Then you say 2 weeks then.
Lordship.
Instead of 1 week, make it 2 weeks.
Lordship. Oblige.
Here. Take this. The name of the road.
Noblest Lordship. Lordship, back to mention items 7 and 14. Set after 3 weeks.
14.
I have not received any instructions. 7 and 14.
Joshua, Mr. Joshua is there. Any objection?
No objection.
7 and 14 on the prayer of Mr. Gauhati at CGC, appearing for the respondents, appearing for the Respondent Union of India, and not objected to by the other side. No. Matter stands adjourned for 2 weeks.
3 weeks.
3 weeks. Item 7. Then what is the other one?
14. Similar bearing.
This is IA. What is the IA for?
Lordship, the IA is seeking for stay of the impugned judgment of the learned
Filed
by the state, my lord.
state.
Yes, my lord.
So what is to be done then?
Lordship, if they,
Any objection filed?
no, they have,
IA is by the state.
IA, no, the writ appeal is by the state, your lordship,
And IA is by?
by the state itself, your lordship.
No, there's no writ
No,
appeal.
no, no.
Item 14 is WPC.
14.
14.
Oh, your lordship, Lordship, I'm sorry, Lordship, I'm speaking about item 12.
Hmm. Similar order in item 14, 3 weeks. No more mention, is it? So Jamil, what we can do is, we'll devote this time up till 3. And if it has to, if more time is required, then we take it up again on Friday.
I'll try to finish before 3. Since in the first step, I have already covered the background in general, I will just come straight to the ambient order now. Page 95, Lordship. Page 95 of the writ appeal. This is the ambient order, which was issued on 5th July 2022.
95.
May I read, Lordship?
This is impugned in the writ petition.
Yes. 5th July 2022. In accordance with the provisions of the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rules 1999, as amended, read with Rules 18, and in the interest of smooth functioning of this Secretariat service, the Honorable Speaker is pleased to delegate to Srimati Grohitono Rio, Additional Secretary, Transport, Nagaland Legislative Assembly Secretariat, the temporary officiating charge of the Secretary to administer the functioning of the Secretariat with effect from 5/7/2022 afternoon and subject to the outcome of WPC number 92 of 2022. 92 is, as I have mentioned, Lordships, this is where the amendment, third amendment has been challenged. Next paragraph, this order shall stand cancelled automatically on the day the appointment of a full-fledged secretary taken over charge. So 2 conditions are given. This is subject to the outcome of WPC 92 of 2022, and it will automatically cancel on the day on the appointment of a full-fledged secretary taken over the charge. So till date, no full-fledged secretary has been appointed. So the private respondent is still discharging the duties.
What was the interim order?
Interim order. Before that.
It was stay of this order.
Yes.
Interim order stayed this order.
Yes.
Later on vacated.
Yes.
So that vacation order is challenged in this appeal.
Yes, Lordship.
Now
That is
this,
correct.
this lady she's a respondent number
1.
in the writ appeal.
Yes.
And in the writ petition?
Respondent number 1, I think. Yeah. Writ petition.
Writ petition also.
In writ petition, respondent number 2, I think. In the writ petition, she was respondent number 2.
Where's the cost title in your writ appeal?
Page 131.
No, in the writ appeal.
Writ appeal, page 2. Starting from page 1.
Appellant is Jenny.
Yes.
Okay. Then respondent
is K. Rio.
K. Rio. Then number 2 is so and so.
The speaker.
Where's your writ petition?
Writ petition starts from page 29.
Okay. Only 2 respondents.
Two respondents.
She's respondent number 1 here, in 2 in the writ petition.
Yes.
Okay.
Yes, Lord. So now I was referring to page 95, the ambient order, and as Lordship has seen, the impugn officiating charge is issued basing on the rule 18. So I have enclosed the rule, the relevant portion, page 97, rule 18. On the strength of this rule 18, the officiating promotion has been issued, Lordship. So this is the relevant issue to be decided in this writ petition as well as the writ appeal. Control and discipline. All officers and staff in the Assembly Secretariat shall be subject to the superintendence and control of the Speaker, provided the Speaker may, by general or special order, delegate to the Secretary any office power in this regard or any of the senior-most officer in the absence of the Secretary. Now here, towards the end of the rule, any of the senior-most officers in the absence of the Secretary. Now that Secretary was not there, so the appointment should be, by assignment should be to a person, senior-most, any of the senior-most. So Lordship may kindly note that. Now, I will come straight to the interim order, which was passed. It's in page 122, but then I will just take your Lordship's attention to the relevant portion only. It starts from page 122. This is order dated 22/7/2022. So the operative portion is at page 129, paragraph 11.2.
Yes.
It's at page 129.
Yes.
May I read, Lordship? 11.2. It is no doubt true that holding up an office on officiating basis is a temporary arrangement. It is also apt to say that despite it being a temporary arrangement, not being a regular posting, holding up an office on the officiating basis is also an important assignment. The extent rules as provided that a member of the Nagaland Assembly Secretariat Service holding the post of additional secretary is eligible to be considered for promotion to the post of secretary in the Nagaland Assembly Secretariat Service only in the event such member has minimum of 2 years continuous service in the grade of additional secretary or equivalent. It is opposite to say that while making officiating arrangement or other such temporary arrangement as a stopgap measure, the aspect of seniority cannot be ignored, since if the senior-most eligible person in the federal cadre is ignored without any discernible reason, then the same may have an adverse impact on the other members in the said service. Such officiating or temporary charge of a higher post is ordinarily given to a member in the federal cadre of the same service who has the eligibility for such post under the extant rules, and his or her case is to be considered first when a situation of giving current or officiating or temporary charge of a higher post arises. From the rules 1999 and the judgment and order dated 12/5/2022, it appears to be an admitted position that the post of Secretary Nagaland Assembly Secretariat Service is to be filled off from the members belong to the general cadre, that is, from the members holding the post enumerated in 3rd Schedule A to 1999 rules as amended. Subject to outcome of the writ petition, WPC number 92 of 2022, the post held by the respondent number 2 has been brought within the review of 3rd Schedule A of 1999 rules as amended only with effect from 18/5/2022 by the 3rd Amendment Rules 2022. It has been observed as fundamental in Chakanat Piku that a candidate eligible in terms of the relevant rules for promotion for a post on regular basis cannot be overlooked for the purpose of any temporary arrangement concerning the post. The proviso to Rule 18 of the 1999 rules as amended appears to have conceived of a situation when there are more than one senior-most officer in the hierarchy to hold the charge of the post of secretary, and the option available to the speaker to delegate such office power to any of them. The case in hand does not appear to be a case of availability of more than one senior-most officer in the Creta Petitional Secretary or equivalent with more than minimum 2 years of continuous service in the federal cadre, because the respondent was only 2 months. Nothing has been placed on record as on date before the court on behalf of the respondent number 2, disclosing a valid reason for making the deviation from the fundamental rule of not to overlook the senior-most persons in the hierarchy while making the temporary officiating arrangement by the ambient order dated 5/7/2022. 12. In the light of the discussions made above and the reasons indicated therein, this court is of the considered view that the petitioner has been able to make out a prima facie case in respect of the ambient order dated 5/7/2022. In such view of the matter, it is provided that till the returnable date, the operation of the ambient order dated 5/7/2022 shall remain suspended. Now, that is the first interim order, and on that day, the speaker was heard, because although it is under day of motion, since it is displayed in the cost list, the speaker, that is the respondent number 1 in the writ petition, has made submission, and on hearing him, the order was passed. The only thing is the private respondent was not there, so without hearing her, the order was passed, as is normally done in the day of motion. Now, can we come to the ambient order? That is at page 138. I will not trouble your lordships to the entire orders. I will just take your lordships to only to the relevant portion where it is necessary. It is in WPC number 92 of 2022, order dated 26/5/2022.
Page number?
Page number 138. This is an order passed in the other writ petition where the rules have been challenged and the interim was sought for, but then in that case, this was passed on 26/5/2022. Since the rule has been challenged, it was heard by a division bench, lordship. Last paragraph in page 139. I am just drawing lordship's attention to the relevant portion only. 139.
Yes.
Last paragraph. The interim prayer made by the petitioners to state the notification dated 18/5/2022. This notification, 18/5/2022, is the amendment of the third amendment. Shall be heard on the next reasonable date. However, any promotion or appointment made pursuant to the Nagaland Legislative Assembly Secretariat Recruitment and Conditions of Service Rules 2022, notified by notification dated 18/5/2022, shall be subject to the outcome of the writ petition. So this was the interim order passed. In the other writ petition, the respondent has taken a plea in the IA that we have suppressed this order where no interim order was passed. But then last paragraph, lordship will find, this talks about the regular promotion or appointment to the post of secretary. After this, I would like to draw your lordship's attention to the ambient order where the stay has been vacated. Lordship will find it page 145. This is passed in IA 116 of 2022, in WPC number 144 of 2022. Order dated is 12/8/2022. Here also, instead of referring to all the background, I will just take your lordship's attention to the relevant portion so as to decide this case. The others are all submissions. I will take your lordship's attention to paragraph 5 of the judgment, ambient judgment, that is 157. Here, my reply to the submission of the learned counsel has been cited, and the operative portion are in the last 3 paragraphs, which are short paragraphs. I will refer to that, and then I will finish my submission there, lordship. Page 157. May I read, lordship?
Yes.
Mr. C.T. Jamir, learned senior counsel appearing for the opposite party, who is the petitioner in the connected petition submitted at the very outset that the applicant, as per the rules of 1999, amended from time to time, is not eligible for a post of Secretary of the Nagaland Legislative Assembly Secretariat, but has been made eligible only by the latest amendment, which is under challenge in the WPC 92 of 2022. That is the notification of 18 May 2022. Therefore, till such time the writ petition challenging the role is disposed, she can neither be considered for a regular appointment nor for temporary appointment to the post of Secretary, Nagaland Legislative Assembly Secretariat, and even for holding current charge of the same, especially when there are other people who have been eligible for appointment to the post as per the rules that has been in existence. Secondly, Mr. C.D. Jamir submitted that the giving of charge through temporary, it may be, should be to the senior most officer of the Assembly Secretariat as contemplated in Rule 18 of the Nagaland Legislative Assembly Secretariat Rules and Conditions of Service, Rules 1999, amended from time to time. Referring to the rule, the learned senior counsel further submitted that word senior most makes it amply clear that it should be none other than the senior most in the Assembly Secretariat who should be given charge of the Secretary. In support of his submission, the learned senior counsel referred to judgment of this court passed in case of Tagana People versus State of Assam and others, reported in 2007 3 GLT 389. Mr. C.D. Jamir also submitted that even if the applicant, by virtue of the latest amendment of the rule, is considered to be eligible for promotion to the post of Secretary, as per the requirement of the rule, she should have served at least minimum 2 years of continuous service in the post. However, in her case, she has not completed 2 years of service counting from the day of amendment was notified, that is 18/5/2022, by which she has been brought into the general gather institute of the rules of 1999. Therefore, she should not have been given the charge of the secretary. Now, from paragraph 6, 7, 8 are the finding. Let me just continue the finding of this in our report. And I would like to pause after one paragraph so that will complete my submission. Very short note. Okay. Paragraph 6. It appears from the interim order and submission of the learned counsel of the parties that applicant was given only current charge of the secretary in the exigency of service till the disposal of the WPC number 92 of 2022, which is pending before this court without bestowing any benefit of the office. Rule 18 of the Nagaland Legislative Assembly Secretariat Rules and Conditions of Service Rules 1999, Second Amendment Rules Incorporated, which has remained as such, empowers the Speaker to appoint or to give charge of the Secretary to any of the senior-most officers of the Assembly Secretariat. The Rule 18 reads as follows. And then role is quoted, control and discipline. I have already read. It's very important, so may just read only the second paragraph. Provided the Speaker may, by general or special order, delegate to the Secretary any office power in this regard or any of the senior-most officer in the absence of the Secretary. Reading the paragraph, it appears that Secretary is already there and the Speaker has to give assignment. But then it talked in a different way that the Secretary promotion. Now, submission was made at once, and the learned single judge has also accepted one aspect, that is, any of the senior-most, they have made two distinctions. Any is one word and senior-most is one word. And submission was advanced that senior-most is preceded by any. Therefore, it can be anyone among the senior-most. So senior-most has been ignored already because in the later stages pending will come. And in the paragraph 6, Lordship will find current charge is not bestowing any benefit
the issue in the entire case is current charge. So if it is not so important for a respondent, why they have preferred, let it be cancelled. But the entire issue in the case is about current charge. When a person is not eligible to hold the post, how can you confer the current charge also? And while granting current charge, seniority rules should not be ignored. It should be on the basis of seniority. And if I'm not eligible, that is another aspect. It's not the case that I'm not eligible. I'm eligible and I'm the only eligible person to be considered for a current charge also. What preferred the respondents to opt for the private respondent? Any of the senior most should be a person, by full submission lordship, should be a person who is eligible to hold the post. Not any time they can hurry. A person who is not eligible should not be picked up. May I continue, lordship? The last paragraph at page 158, paragraph 6. Last paragraph.
Yes.
As can be seen, the word any appearing in the second paragraph of the rule precedes the word senior most. Therefore, reading the whole rule would mean that the speaker can delegate charge of any of the office to any of the senior most officer in the secretariat. The applicant, being one of the senior most, is therefore eligible to hold the temporary charge of the secretary as per the provisions of this rule. As such, I am of the view that the honorable speaker, while exercising his discretionary power under Rule 18 of the Nagaland Legislative Assembly Secretariat Rules and Conditions of Service Rules 1999, Second Amendment Rules Incorporated, has not committed any illegality which violates the right of anybody, including the opposite party number 1, that is the writ petitioner. Now, I have read out the paragraph 11.2, which was passed in the first interim order. That is one order, and this is another order contrary. So the two very single judges' orders are contradictory to each other. Therefore, it is a fit case for the Honorable Court to resolve which one is correct and what the law says. Any of the senior most means the word any precedes senior most, any should be taken. That is the conclusion arrived by the learned single judge lordships. But the judgment, Jagannath Bhiku's judgment, even if it is for current charge or temporary charge, seniority should not be ignored. That is the law. But in the entire judgment, that is not referred to. I have submitted, but in the finding, it is not relevant in our case, that is also not observed, nothing has been observed. Now, paragraph 7, lordships. It is also very interesting. On one hand, the learned single judge is saying that seniority has not been settled yet. On the other hand, a finding was arrived that at this stage, it cannot be accepted that the petitioner is the senior most. If the seniority is not settled, then who can be senior, who can be junior? Conclusion cannot be arrived. Paragraph 7. Further, there is nothing in the report to show that the opposite party number 1, as claimed by her, is the senior most in the Assembly Secretariat, and seniority among the officers, especially in the rank of additional secretaries, have been determined. 2. It is true that the initial appointment orders show that applicant was appointed one day later than the opposite party number 1. The seniority between them has not been determined so far. Seniority has not been determined. That is what the learned single judge has, right? Therefore, the claim of opposite party number 1 that she is the senior most in the Assembly Secretariat cannot be accepted as the gospel truth at this juncture. On what basis? If the seniority is not determined, who is senior, who is junior is not determined, how the court can also arrive that she cannot be the senior most. But the fact remains, the order says, since 2019, I'm holding the post of additional secretary who is eligible to consider for a post of secretary. But admittedly, as admitted by the respondent number 1 in the present appeal, she has admitted that by 18/5/2022 notification, that is the third amendment, the date of effective date is 18/5/2022. She was made eligible to hold the post of secretary by virtue of the amendment, third amendment act. That means she became eligible from 18/5/2022 because she was inside the cadre. And according to them, she was brought to the cadre.
Though she was additional secretary,
Gotcha.
but she came in the zone of consideration only from that notification.
Yes,
So from that notification is just about 2 months.
yes.
That's what you're saying.
Yes. And when the seniority is not determined as held by the elder single judge, how a conclusion can be arrived that no, seniority not determined, then who is senior, it is not known. But then at the same time, the learned single judge is saying that with due respect, it cannot be accepted that she is the senior most. But I'm holding the charge of additional secretary since 2019, orders have. And they are not disputing that. And Lordship, what I have submitted, Lordship, you kindly see what my learned friend has submitted. Page 152. Mr. Lordship,
Yes.
paragraph 3. Mr. Takamasa, learned senior counsel, appearing for applicant, submitted that the rules of 1999, after the third amendment, that is 18/5/2022, and it stands today, has made the applicant also eligible for promotion to the post of secretary of the Nagaland Legislative Assembly Secretary. So it is 18/5/2022, on which date she was made eligible to be considered, and counting from that date, about 2 months only, 5th July 2022 is the end order. Where she was given the current charge. Am I clear, Roger? It is the contention.
You are going on the eligibility, isn't it?
Yes. Yes,
Eligibility means 2 months.
yes,
Otherwise, additional secretary was before that,
yes.
isn't it?
The petitioner. Additional secretary was before that,
Hmm.
but it was an ex-cadre post.
Ex-cadre post. So simply as additional secretary transport, there was no question of promotion to secretary.
Yes,
Only after the amendment,
yes,
she came within the consideration zone.
yes, yes,
By taking into account that provision, it's just 2 months.
yes.
That is what you're
Yes.
saying. Okay.
Now, we will continue. Paragraph 7, I was reading. First part I have read, and second part. This is the relevant point which we are discussing at the moment. Page 159.
Yes,
Second, last paragraph, Lordship, may I read?
yes.
The third amendment, which is under challenge in the BPC 92 of 2022, has no doubt reorganized the service of the employees of the Assembly Secretary, especially from joint secretary to secretary, and that has brought the service of the applicant in the general category C. It is by restructuring only she was brought to the general category, and that has made her eligible for promotion to the post of secretary. As per clause 5 of the third amendment, clearly third amendment is mentioned. There is no other amendment. And third amendment is starting from, reporting from 18/5/2022. The third amendment, the Secretary of the Assembly Secretary is to be appointed by the governor on the recommendation of the Speaker in consultation with the Chief Minister, and as per the clause 7P of the amended rules, that is the third amendment. The post of secretary is to be filled up by promotion from the grade of additional secretary or equivalent in the Assembly Secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the appointing authority.
the word if deemed fit by the appointing authority makes it amply clear that promotion to the post of secretary to the assembly secretariat is by selection and not by seniority. This is on the basis of the submission made by the council for the applicant for vacating the interim stay. Selection is relevant for regular promotion. And even the current temporary charge, there was no selection at all. But in order to vacate the interim stay, it is by selection. Basing on that, order was passed.
Where's that?
Selection is relevant for regular promotion.
Where's that selection part?
Let me read again, Lordship. Page 160,
Yes.
sixth line,
Mm.
extreme right, the sentence starts with there. The words, if deemed fit by the appointing authority, makes it amply clear that to the post of secretary to the assembly secretariat is by selection and not by seniority.
Where's that word from?
Page 160.
No, I know that, but from this, if deemed fit is from coming from which provision?
That is on the basis of the submission made by the council for the opposite party.
No, the words, if it deems fit, this is given somewhere in the rules.
Yes, Lordship.
Where, which rules?
Rule 7B.
7B. Do we have the amendment, by the way, in this?
Rule 7B is.
Is it enclosed anywhere in this appeal?
Page 90, Lordship.
90?
90.
90. This is the amendment which came
Yes.
into force
Right.
after
It's
the,
not
af-
mentioned here.
no, after that judgment of this court. Within 6-8 days, some
6
amendment,
days, yes.
within 6 days, amendment was made.
Yes,
So this is the amendment.
this is the one, yes.
Okay, then this amendment, by way of this amendment, the additional secretary, transport,
Interchangeable.
transport has been brought within the zone of consideration. Correct?
Yes,
And it was challenged by way of WPC 92.
correct,
92 came to be finally dismissed.
yes.
Correct?
Yes,
As on today, this notification stands.
yes,
But in the meantime, there's been some interim arrangement of placing the respondent number 1 to the post of secretary,
yes. It was
And-
from before,
which you have challenged
yes,
by filing WPC 144.
yes,
And in the interim, protection was given,
yes,
but later on it was vacated.
yes.
Hmm.
So against that, they resonated. Officiating promotion only. The issue is on that.
Basically,
Who should hold the current
your
charge?
writ petition is basically who should hold the charge.
Yes,
That's all.
yes. Number one.
But
Secondly-
as per the amendment rules, you are eligible.
I was eligible from before.
You were eligible from before, even after amendment, you are still eligible. But only after amendment, the respondent number 1 becomes eligible.
Yes,
And why is she not appointed as secretary? Because she has only completed 2 months. Is that why?
that's why. Why she is appointed when she is only 2 months? Because role requires 2 years.
So,
7B, Lordship may kindly see.
so they also accept that she has done only 2 months. Okay,
Kindly come to page 91.
91.
This is rule 7B. From the top.
If deemed fit by the appointing authority.
In the third schedule A,
Hmm.
against rule number 1, column 7, the following shall replace the existing entry. And then by promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years continuous service in the grade, if deemed fit by the appointment. So this is what Lordship was asking. If deemed fit.
So
by the
what,
appointment.
what does it mean?
This is for normal regular promotion. But the Indian order was issued under Rule 18, which talks about the temporary charge to whom it should be given. Speaker has the power, but that temporary charge should be given to the senior most, any of the senior most. So to come within the zone of any of the senior most, the 2 years she has not completed the private respondent. Therefore, why she was picked up contrary to the rules? That was the question in WPC 144.
So this justification is given by the learned single judge saying that selection, I mean, the appointment is not just by seniority, it is by selection.
Yes,
So that's why, just because you're claiming seniority, that cannot be the ground.
yes.
That is what has been
From
said.
where he has arrived at that conclusion, and the selection is for regular promotion. And in our case, selection was also not done. Even going by the finding of learned single judge,
And you
where
say,
selection was here.
and you say Rule 18 is not selection. Rule 18 is the power of the speaker to place anybody, isn't it?
He has the power.
Rule 18 has been invoked. It is not a question of selection for regular appointment.
Yes,
It is only for temporary appointment.
yes,
So this particular provision is not relevant.
yes,
That's what you're saying.
yes. Now, to vacate the interim stay, because I'm coming to the concluding part, Lordship. I was reading paragraph 7 and the last part I have already read out.
Yes.
Now, the last part, that is paragraph 8. Taking into view the facts and circumstances and the relevant rules, it appears that the interim order was passed due to non-presentation of the relevant rules and the facts and circumstances rapidly. I would like to pause here, Lordship. Which role was not presented so as to decide this issue? Because learned single judge is saying that relevant provision was not placed to the court and interim order was obtained. That is what the single judge wants to say. So my question is, which provision was not brought? Which relevant provision covers for giving temporary current charge? To my mind, it is only Rule 18. And Rule 18 was discussed while granting the interim stay initially. It was discussed fully. So which provision was not brought to the notice of the court so as to obtain an interim order? That is my question, Lordship.
And Rule 18 is also mentioned in the impugn order. Isn't it?
Rule 18 was the only relevant provision. Kindly come to page 126 and 127. I will just show where the learned single judge has discussed and referred Rule 18. In paragraph 4, in the 9th line, Rule 18 is mentioned. It was discussed, which is relevant so as to decide the issue involved in the case. As your Lordship correct, it's somewhere in the middle of line 9. Rule 18.
But this is your submission.
Yes. And again, come to the next page, page 127. Rule 18. 11th line. It is the submission of the counsel for the speaker. Rule 18 is mentioned. It was argued. And in paragraph 6 also,
again, Rule 18 is mentioned. And in paragraph 11, Rule 18 is mentioned twice. So my question is, which role, which provision was not placed before the court so as to obtain an interim order surreptitiously?
Rule 18 was there before amendment
Yes,
and it remains after amendment. also.
yes,
Okay.
it was same, no effect, no change. Rule 18, it was not that. Therefore, it is not relevant even in the case of WPC 92, where the amendment was challenged. We are not questioning this. The issue in WPC 144 was only pertaining to Rule 18. Who should hold the temporary proceeding charge? Speaker has the power. And another submission was made by the counsel for the private respondent that, look, by way of passing the interim order, the entire petition was decided. That should not happen. That was the submission. But by vacating the interim stay, entire petition has also been decided. There is nothing left to be considered now because it is temporary promotion.
That exactly was what was plaguing on my mind. The entire effort of the writ petition is
temporary
to take away that temporary arrangement.
Yes.
Now, if the interim orders pass this way or that way, what is left to be decided?
In WPC 92 also, she said that she has come to the gather. By the amendment. So, in view of the two conflicting orders.
Instead of dwelling upon this issue, why not the parties sort it out in the writ petition?
Yes, but the two conflicting orders of the letter single judge is to be clarified first.
Similar to your stand today, the stand could have been taken by Mr. Takamas also in another writ appeal. That why interim order has not been given.
And very unfortunate, Lordship, it was kept CAB on 3rd of February 2023. Judgment came in April 2024. Thereafter also, they have not taken any step so as to fill up the post by regular process. Why? If any consideration is taken, private respondent will not be eligible. She has not completed 2 years. Now that she's already completed 2 years, she will come proudly that, look, I'm eligible person because I have completed 2 years. That is what they are playing.
Now completed, is it?
Yes, now completed.
The impugned order
Going
is.
by the 3rd amendment. She has completed 2 years.
Okay.
So her mission is accomplished.
July.
And it is the speaker who should take initiative to fill up the post on a regular basis. After the judgment, they are feeling very proud that we have not challenged the judgment. There are so many reasons we have not challenged. Yes, WPC 92 has been dismissed. Yes, dismissed. On what ground? There are so many reasons, but it is dismissed. It has nothing to do with dismiss. It has absolutely nothing to do because Rule 18 has not been touched by the 3rd amendment. So whether it is dismissed, allowed, it is of no consequence. But if the writ petition is allowed, automatically everything will go. That's how, to that extent, it was relevant. And since there was no interim stay in favor of the private respondent, in favor of the petitioner, the present appellant, she was compelled to challenge temporary petitioning provision. Otherwise, subsequently, they will take a stand of look. Now that you are saying that I'm not eligible, but you have not challenged at that point of time. That's how we were compelled to challenge this. So I believe, Lordship, I have given an assurance that I will not cross street. That may I stop there. Two conflicting orders of the two learned single judges should be clarified by this letter.
See, regarding Mr. Takamasa's submission and Mr. TV Jammy's submission. It's gonna take some time,
Yes.
isn't it?
My lord, did it be Friday? Because it's true.
Yes, there are few matters left.
Yes, so my lord, will it be on Friday?
Yeah.
But then, since
That matter we have fixed for Friday. You can have this as the second item.
My respectful submission is that let Friday subject to the lordship. Let Friday be a DP day, so that this matter can be crushed out once for all, instead of keeping it part.
I don't know.
Is there any difficulty, lordships, for considering tomorrow? That's why. So Friday, let it be instead of, half division in half single, why not we have a DP on Friday so that this issue is crushed out?
Just a minute. What is the situation tomorrow? This is prepared. Tomorrow we will see how many matters are there. On the entire day. It's not we can get to a perspective. Okay. Now we can come and solve this. Why wait for Friday? We can afford that tomorrow. That needs to be done.
I will also take 5 minutes only to reply.
But it will take, brother and me will take some time to digest.
Yes.
So I think we'll have it on Friday. Since few matters already listed tomorrow. So Friday will, and we try to complete. I think the point involved is
It's
not.
very simple. I have taken.
Not very wide.
Today I have taken 40 minutes and in the other day, before lunch, I have taken only 20 minutes. The other day, the lordship was mentioning, yesterday, the lordship was mentioning about good candidate. Now, lordship, on the speaker, hello, I'm not in the merit today. I'm not going to the merit. Whether the matter is only about passing up in the ex party in the remote. Which was which is so the principle of prima facie case, balance of quantity, irreparable loss. Now, my lord, the as lordship has already pointed out, the PPC 144 is subject to the outcome of this case because a submission was made before when the matter was listed that till the disposal of the legal field, the petition should not be disposed. So it is waiting disposal of the legal field, which is only on the petition to the reporter, rightly or wrongly, my lord, I am there since 2022. Holding current judge. Now, by listening to the submission of my learned friend and the observation made by lordship, whether, my lord, we can encroach upon the merit, the jurisdiction of another single judge in 144, because the merit has been decided there. Whoever wins, then the question of opportunity of appeal will be there. So, my lord, by giving certain findings of the merit at this stage, where the IA, whereby which agreement was modified is challenged, whether that will have a direct impact bearing on the decision and on the case to be heard before the level single judge. I'm not complaining anything today. That aspect has to be considered.
Okay,
We'll go
okay.
for that on Friday. I'm not giving any further sufficient there, just a point of order. Because Malad, this is only for modification of interim.
Lordship.
And if we intend to the merit at this stage, I'm not going to this issue whether.
Yes,
whether single bench has
Mr.
gone to the
Takamasa,
merit or not, that's a
we.
different issue.
we
Third
are-
Amendment Act was challenged in WPC 92.
So that
When the matter was pending before a division bench, the learned single judge, while vacating the interim stay, has entered into that subject also and decided.
all this issue should be raised.
See, we are aware of what Mr. Takamasa is saying. But at the same time, we are also wondering why parties did not impress upon the learned single judge at the relevant time. Leave alone this vacation and all that. Let us go to the writ petition and decide the matter.
Yes. We have
Parties,
submitted.
parties could have done that.
Then we have done.
This be disposed of.
But because what has happened also with Kenya, this writ appeal was tagged along with 92,
92.
where the rule was challenged. So, my lord, we could not proceed on this issue because, my lord, initially when the writ, the service rule was challenged under the PPC 92,
No, 144 and 92 was tagged together.
my lord, 92 was before division bench because
Yes.
the rule was challenged and the present writ appeal. The present writ appeal and the PPC 92 were tagged along.
No, I was talking about 144.
That is why I'm saying, my lord raised an order passed in 144.
Hmm.
That was sufficient of my learned friend that
Hmm.
subject to the final outcome of the writ appeal.
Hmm.
144 should not be heard. So there's an order
Okay,
passed.
okay.
And the learned single judge has made a judicial sentence in the matters, cease of the matter by division bench. It was not decided. It was not, could not proceed further.
Okay.
Then 92 and the present writ appeal were tagged along.
Hmm.
And so that way only when 92 was heard. That time only the division bench of this honorable court bifurcated the two cases
Okay,
and it was released.
okay.
That is why we could not proceed.
All right, all right.
So I'll continue on Friday.
Friday. Okay. He's right, hard in part. List again on Friday. As part had.
Much obliged.
For admission, item number 3.
As I mentioned earlier,
Hmm.
I'm not receiving the instruction.
Matter may come up when.
After 2 weeks.
Objection, my lord. This is habeas corpus matter and time has been given to the central government. And I have been illegally detained for now 3 months. Until date, my representation has not been considered by the central government.
Matter was listed on 7/8.
Yes, my lord.
Thereafter? Thereafter on 21st. What about the state?
May I please, Lordship? My lord, this morning only I have filed the affidavit.
Which affidavit? In this case?
Yes, yes. In that,
Which one? Which case?
11 of the.
This is 10.
Yes. Your
What
Lordship.
about 10?
Then, my lord, the ground taken in the item number 3 and the 4 are same. That is why the only in the item number, WBC number 11 in that only the status.
They are same as these are analogous matters or what? Huh? Are these analogous matters?
My lord, the grounds taken here are analogous.
Similar
They
ground.
were arrested on the same date,
Yes,
same grounds.
Same case.
yes.
My lord, same case.
So WPC
10 and 11.
affidavit 11
Yes.
Affidavit will cover the case in WPC 10 also. So where's the affidavit?
I've already filed it. This morning only I filed it.
So you call the affidavit, we'll see. You have a spare copy? No.
No, it's okay. My lord, in the affidavit, there is typical error, my lord. In the case number, it should be 11, but I've written 10. So it should be 11.
When did you discover that? After filing?
This morning, yes. This morning.
Anyway, we'll see. Yes. You may start.
Yes, your lordships. Lordships, the petitioner hearing is seeking for revocation of the detention order dated 30 May 2024.
Page number 18.
Yes, my lord. No, my lord, a brief gist.
Please, lordship, my lord, that the item number 4 will be taken up first, because in that item number 4, I filed it.
But you said it can be applied in this case also. That affidavit is common for both the cases.
Yes.
So how does it matter whether you take up this one or that one first? No, he says that although it's written 10, actually it's to be 11. That's what he said. Anyway, we'll see. Let him start.
My lord, a brief gist of the case is that a sumoto FIR was filed on 6/4/2024.
Okay.
Stating that on 5/4/2024, during routine check-in, a vehicle was checked and thereby 239 grams of heroin were seized inside that vehicle, along with three accused persons. And thereafter, during interrogation, the name of the present detainee was revealed. Only during interrogation. I was not arrested on date 5.
Okay.
During interrogation, my name was revealed. And thereafter, on 12/4/2024, I was arrested along with my husband.
Along with your husband?
Yes, my lord.
He's
The
also-
husband's petition is number 11. This is for the wife, Adilu Chawang. It's filed by the brother-in-law of the detainee.
WP criminal 10 is?
10 is the detainee is Adilu Chawang.
And who has filed this?
The brother-in-law.
Brother-in-law.
Yes, my lord.
Okay.
Of the detainee.
And similarly, item
11.
11 also by the brother-in-law.
By the brother of the detainee.
Okay, okay. Brother and brother-in-law.
Yes, my lord.
Okay.
After my lord, on 12/4/2024, the present detainee along with her husband was arrested. They were both arrested.
On
and thereafter
12/4.
12/4/2024.
Okay.
And thereafter, by a letter dated 17/5/2024, the additional DG put up a proposal before the special secretary home to detain the present detainee. And thereafter, on 30th May 2024, the special secretary home passed the order and detained the present detainee under section 3 subclause 1 of the PIT NDPS Act, my lord.
Do you have the NDNPS Act, Courtmaster? Yes, then. So what is wrong in this detention?
Yes, my lord, I'm coming to my grounds for this thing, for setting aside the impugned order. So the detention was passed on
35/2024,
my lord.
Okay, now after this detention order, what is required?
Thereafter, I submitted my representation.
Representation.
On 12/6/2024. 12/6/2024.
Before?
12/6/2024. My representation.
Before whom?
Before the detaining authority, the state government, the central government, and the chairman of PIT NDPS, my lord.
Okay.
Advisory board.
This detention order was passed by whom?
By the special secretary home.
Special secretary.
Yes, my lord.
Then your appeal, your representation also is before that same authority.
Yes, my lord. Before the Special Secretary Home, the government of Nagaland through the Chief Secretary, then the central government through the Joint Secretary of Finance and the Chairman NDPS Advisory Board.
After the detention order, within a certain period of time, you are supposed to give the grounds for detention, isn't it?
Yes, my lord.
You have been given.
Yes, my lord.
There's no dispute
Yes,
about
my
that.
lord. There's no dispute.
Then in terms of the grounds given to you, you submit your representation.
Yes, my lord. On
Before the special secretary as well as before the union
the state government, the central government, and the Chairman Advisory Board.
chairman advisory board.
Yes, my lord.
This is in terms of which provision?
Yes, my lord. It is as per. It would be as per Article 22, subclause 5, my lord.
Article means of which provision?
Constitution of India.
Article 22.
Yes, my lord. Subclause 5, clause 5, my lord.
Now, because I'm asking you because you were saying that your representation has not been disposed of
Yes, my lord.
by the Union of India
Yes, my lord. And the advisory board.
advisory
And
board.
as per
also.
section 12 of the NDPS Act, the central government has every right to revoke my detention order.
Okay.
As per section 12 of the NDPS Act.
And
central
what about the
government-
advisory board?
My lord, the advisory board also has a right to consider my representation.
No, the role of advisory board comes at what stage?
Now, once my detention order is passed,
then
within 5 weeks,
Ah.
in this NDPS Act, within 5 weeks,
It has to go
the
to the,
government has to consider the advisory board,
and advisory board will,
submit a report to the government.
and based on that,
Based on that, the government may extend my detention period. So, my lord,
the recommendation of the advisory board is binding upon the government?
may not be, my lord. Maybe, may not be. But the opinion can be given by the advisory board.
Supposing the advisory board says that the detention order is not called for, then?
Then, my lord, the government may revoke.
No, government can still say that, no, we will retain him.
Yes, my lord.
We will not accept your recommendation.
Yes, my lord.
So it's not binding.
No, the government may take or may not take, my lord. But no, it will be binding, my lord. The government shall revoke. As per section 9F of the NDPS Act, my lord.
So it's binding upon the government.
Yes, my lord.
Okay. In your case, what has happened? Advisory board has not given any recommendation.
Now, the advisory board has not considered my representation.
When did you file the advisory board, before the advisory board?
12/6/2024, my lord.
That was before the special secretary.
Yes, and also I have given the same on, I've given to all the concerned authorities on the same day. The Joint Secretary, NDPS, Ministry of Finance, then the Chief Secretary, Government of Nagaland.
Then annexure F, page 26, is the order passed by the special secretary.
Yes, and thereafter, on date 13 June 2024, the Special Secretary Home rejected my representation.
And also the chief secretary.
Yes, my lord. But however, the advisory board and the central government has never considered my representation till date, my lord. I have not received any communication from the advisory board or from the central government, my lord, that my representation has been considered. Therefore, been agreed fine before this honorable court. So, my lord, to support my first ground, that is, the advisory board has not disposed of my representation, I would like to rely on a citation of the Honorable Supreme Court.
Yes.
In the matter of Gracie versus State of Kerala, my lord.
No, this is not Supreme Court.
It's Supreme Court, my lord.
In the High Court of Gauhati.
No, that will be the second one, my lord. I have given two.
Okay.
Yes. The first one is Gracie versus State of Kerala.
Yes.
My lord, the relevant portion is at para 8. And for the convenience of this court, I've highlighted the relevant portion, my lord. May I read, my lord?
Yes.
Thus, any representation of the detainee against the order of detention, against the order of his detention, has to be considered and decided by the detaining authority, and the requirement of its separate consideration by the advisory board, being an additional requirement implied by reading together clause 4 and 5 of the Article 22. Even though express mention in Article 22 is only of the detaining authority. So, my lord, through this, the advisory board has to consider my representation. Moreover, the order of detention is by the detaining authority, and so also the order of its revocation, if the representation is accepted, the advisory board's role being merely advisory in nature without the power to make any order itself, it is not as if that there are two separate and distinct provisions for representation of the two different authorities, the detaining authority and the advisory board, both having independent powers to act on its own, my lord. Then coming down to para 9, my lord, it is settled that the aforesaid dual obligation of consideration of the detainee's representation by the advisory board and independently by the detaining authority flows from Article 22(5). Therefore, my lord, there is an obligation on the part of the advisory board to consider my representation, which the advisory board has failed to do. And I have not been communicated with any order till date regarding the disposal of my representation dated 12/6/2024, my lord. Therefore, my lord, I would like to rely on the citation of the Honorable.
But give us the
Gauhati
Constitution of India. Constitution of India, direct. Advisory board can give its opinion.
Yes, my lord.
And the central government also can give its opinion.
Yes, my lord.
Both are independent.
Yes, my lord.
This is what this order says,
Yes, my lord.
isn't it?
Yes, my lord.
But does it say that if there is no disposal of representation by the government of India or Union of India, the detention becomes illegal?
My lord, I'll come to that. My second contention, that is.
22(5).
My lord, my next citation is of the Honorable Gauhati High Court.
Yes.
The Honorable Gauhati High Court in Alia Begum versus State of Assam, my lord.
This is also under NDNPS.
Yes, my lord, PTNDPS. The relevant para is at para 19, my lord. Para 19, my lord.
Yes.
May I read, my lord?
Yes.
Though Mr. D. Mazumdar, learned Additional Advocate General, has raised a technical objection and have submitted that the allegation of breach of Section 3, subclause 2, 9B and C has no factual foundation. The fact remains that the compliance of this provision are sine qua non. It is also a matter of record, my lord, this is important. It is also a matter of record that though representation was made to the advisory board, there is nothing on record to show that the same has been considered. The same would be violative of Article 21 and 22, subclause 5 of the Constitution of India, my lord.
Nine B, 9C, what is that?
9B and C. The advisory board is to be constituted within 5 weeks, and C is the the report is to be submitted within 11 weeks. My lord, my next contention would be the failure of the central government to revoke my detention order or to consider my representation. And to support my contention, I would like to rely on the citation of this Honorable Gauhati High Court in Ashuli versus State of Nagaland.
Advisory board has not been constituted in this case.
Yes, it has been constituted.
In your case,
Yes, my lord.
when was it constituted?
It was constituted. I said before that I don't know when it was constituted, but the detainees were presented before the advisory board on 15/6/2024, my lord.
15/6,
Yes, my lord.
2024.
Yes, my lord.
Then what is the outcome?
My lord, till date, I have not been given any, I have not been communicated with any order.
Is there anything, Mr. Form, in your affidavit regarding the advisory board?
My lord, let him first.
Yes or
complete
no?
his
Just tell me
submission, my lord.
that. Tell us yes or no.
Yes, I have to justify, my lord.
I'm not asking you the justification. Council is saying that they were taken before the advisory board on 15/6. So is there any report or
Yes, my lord.
any
My lord,
recommendation?
advisory board was seated on 30/7/2024.
Not 15/6.
No. I've annexed in the affidavit, my lord.
You asked this. Jamadar to come.
I've annexed in my affidavit as annexer A.
Okay, we'll come to that. So you say 15/6/24,
Yes,
that any were taken before the advisory board,
Yes, my lord.
but you have not been communicated about any order.
Yes, my lord.
Okay.
Now my second condition that the central government till date has not considered my representation. And as per section 12 of the PNDPS Act, the central government has the authority to revoke the detention order. And to support my contention, I would like to rely on the citation of the Honorable Gauhati according to the State of Nagaland. The relevant para is at, relevant portion is at para 19, my lord. We are in, my lord. Para 19, page 16, my lord.
Yes.
Taking into account that in the instant case, there has been an unexplained delay of disposal of the representation by the state government, and further, the central government till date has not disposed of the representation. We are of the opinion that the detention order and the further consequential order have become bad on account of delay in disposal of the representation as well as the non-conservation of the representation by the central government, for which the detention order as well as the consequential orders passed thereafter have been rendered fatal.
So in this case, both central government and state government
State government has delayed.
delayed, central
And the
government
central government has never
has not. But in your case,
There is no delay on the part of the state government.
There's
On
no
the
delay.
detaining authority, no delay.
no delay.
Yes, ma'am.
Only central government has not disposed of.
Yes, has not disposed till date.
Whether it has reached the central government or not.
Yes, my lord, it has reached.
How?
My lord, may I kindly take this, my lord, to page 29, 28 of my petition.
Postal receipt?
Yes. To the jail, I've sent this to the central government. And thereafter, the item was delivered on 18/6/2024, my lord.
When did you send it? Send
It was sent to the jail.
date. 12/6, is it?
1/6.
12/6/24.
Yes, my lord.
Then delivered on
18/6. 18/6/2024.
it is addressed to whom?
It's addressed to the Joint Secretary, PNDPS, Ministry of Finance, Government of India.
Have you enclosed a copy of that anyway?
My lord, now I have enclosed my representation. The representation, yes.
Where is that?
And there. it's
Copy
at
two.
page number 22.
22.
Yes, my lord.
No, this is to the special secretary.
Yes.
But copy to
and
joint
copy to the
secretary.
Joint Secretary, PNDPS. I serve copy to all the required persons.
Mr. Muli, do you get instructions in this kind of cases? Does the Union of India dispose of representation? No, I'm not asking you about this case. Generally, you must be appearing in all these kind of cases, PS cases, where representations are sent to the Union of Government of India, like here, Joint Secretary, Ministry of Finance. Ministry of Finance?
Yes, my lord.
Why finance?
That is, they're just given to us.
What is the role of finance in this case? Address given to you by whom?
By the detaining authority.
Finance.
No, it's finance.
Mr. Muli, you must assist the court. Although you may not get the instruction in this case, but generally when you appear in this kind of cases, what is the situation when representations are sent to the Joint Secretary? What are your instructions in this kind of cases? No. Considered and communicated. And does a copy come to you also? Then what kind of instructions do they give you then? Verbal instructions. In other cases, not in this case. This is a fairly new case. In all cases, disposed cases, any other cases which you have been appearing in the past, normally, what kind of instructions do you get? In which, what is the contents of the affidavit? Do they say that representation was considered and disposed of? And this is the order? You get that kind of orders? And it is disposed of by whom? Joint Secretary Finance? So there's something wrong here then. Ministry of Finance.
Department of Revenue, Ministry of Finance, room number 202, Jivantara Building, second floor, Parliament Street, New Delhi.
Department of Revenue,
Yes, my lord.
from where you're seeing that?
My lord, this was information to the detainee. Ministry of Finance.
12/6/24, received on 18/6/24. June, July, August, almost more than 2 months now. So from the grounds you have taken is that representation has not been disposed of by the Union of India, Joint Secretary, whoever, and also by the advisory board constituted by the state,
Yes, my lord.
despite the fact that you were made to appear before the advisory board
Yes, my lord.
on 15/6, according to you, and different date for, as Mr. Thivapom has said. Is there any such kind of prescribed time schedule for considering and dispose of the representation?
No, my lord, there is no fixed.
It is not there.
But as soon as possible, as per Article 22.
That is your one ground.
Yes, my lord.
What is the other ground?
Look, my first ground is representation has not been disposed of by the advisory board. Second is the central government. And my third ground is that the detention order was not passed to the subjective satisfaction of the detaining authority, my lord.
How do we say that? How do you say that? Subjective satisfaction?
If I may kindly take my lord to my detention order.
Yes.
Page number 21, my lord.
21 is grounds of detention.
Yes, my lord.
Communicated to you.
Yes, my lord. Now, if I can kindly take my lord to this, then the detention, the main detention order, there is nothing in the detention order that I'm likely to be released on bail. No reason has been cited that on what grounds I'm likely to be released on bail. And that my detention is necessary. The government, the detaining authority should be satisfied that there is a real possibility of me releasing on bail.
In this order dated 30th of May.
Yes, my lord. There's nothing in the order, my lord, stating that I'm in custody and I'm likely to be released on bail. There is no reason, no grounds given by the detaining authority that on what grounds I'm likely to be released on bail, my lord. And the detention order was it was not to the subjective satisfaction of the detaining authority, my lord. And to support my contention, my lord, I would like to rely on a citation of the Honorable Supreme Court. In the matter of Budrom, Ongao Singh versus State of Manipur and others. The relevant portion is at para 9, my lord. May I read, my lord? Para 9. In view of the above, it can be held that there is no prohibition in law to pass the detention order in respect of a person who is already in custody in respect of a criminal case. However, if the detention order is challenged, the detaining authority has to satisfy the court the following facts. My lord, my support is in at para 2, my lord. there are reliable materials before the state authority on the basis of which he would have reason to believe that there was a real possibility of his release on bail. And further on being released on bail, he would probably indulge in activities which are prejudiced to public order. So, my lord, here there is no subjective satisfaction of the detaining authority to pass the detention order. And then on this grounds, I am seeking for the revocation of the detention order dated 30 May 2024, my lord. Then, my lord, coming to my
No, just a minute,
foreground.
just a minute. This judgment is from the order passed by the Gauhati High Court Impal bench.
No, my lord, Supreme Court. The Honorable Supreme Court.
Oh, it's Supreme Court, I know. It is, challenge was made against the order passed by the High Court.
Yes, my lord.
Impal bench.
Yes, my lord.
That's what I'm saying.
My lord.
Now, what was the order of the High Court?
It's not given in detailed.
Dismissing the habeas corpus petition.
Yes, my lord.
Challenging the order of detention of appellant's son under the National Security Act. It is given, it starts from the first paragraph itself.
Yes, my lord.
You are showing us only the operative portion which is favorable to you, but we have to appreciate the entire thing, na?
Yes, my lord.
That is why we can't be so fast also. Mm. The detainee made representation, central government, government of Manipur, which stood rejected. Detention order was confirmed. Appellant filed with petition challenging so and so. It was dismissed. Then there's no prohibition in law to pass detention order in respect of person. The authority should be aware that terms of the present like to be released on pay. Okay. What next?
Now, my lord, coming to my fourth contention. The detainee was served the detention order in a language which he is not familiar with, my lord.
What language is that?
English.
English.
Yes. He's not familiar with the language English, my lord.
Then how did she write the representation?
My lord, detention order have to be served to the detainee in the language he understands.
Okay. It was not served. Fine.
Yes.
But then you were informed about the grounds of detention. And against that grounds, you could very well submit your representation.
No, my lord, the mandate of the constitution is that it should be given in the language and the script the detainee understands.
Where is the prejudice caused to you? That's what I'm saying.
It was not served to me in a language I understand. I understand Hindi, Nagamese, and Manipuri.
But you could write in your representation.
That representation is a different issue, my lord, but the order was served to me in the language I understand or not. If the order is not served to me, if the detention order is not served to me in a language I understand, then that is not in consonant with the Constitution under Article 22, my lord.
The detainee is illiterate or what?
She is not illiterate, my lord. She understands Hindi, Manipuri, and Nagamese.
Because English is not a foreign language for Indians.
Yes, my lord. but-
Especially in this part of the country, people speak very well, very good English.
Yes, my lord. But the constitution says that the detention order should be given in a language the detainee understands.
Okay, which paragraph?
And as per,
This is as per the Gauhati High Court, no, Supreme Court.
Supreme Court, my lord.
Page, a paragraph.
My lord, at para 12, my lord. May I read, my lord? We do not agree with the High Court in its conclusion that in every case, communication of grounds of detention in English, so long as it continues to be the official language of the state, is enough compliance with the requirement of the Constitution. If the detained person is conversant with English language, he will naturally be in a position to understand the gravamen of charge against him and the fact and circumstances on which the order of the detention is based. But to a person who is not so conversant with English language, in order to satisfy the requirement of the Constitution, the detainee must be given the grounds in a language which he can understand and in a script which he can read, if he is a literate person. my lord. That is the mandate of the Constitution. my lord.
So in this case, they should have given that person Marathi.
Yes, my lord.
It pertains to Maharashtra state.
Yes, my lord. Hare Krishna. And my lord, lastly, I've been booked under the appropriate provision of law, and I can be tried and punished under that provision of law. So the detention is illegal and unnecessary. my lord.
Are you a habitual offender?
My lord, I cannot be termed as an habitual offender.
That means
The allegation is there's a case pending against me, but I've never been convicted.
there's a case pending against you.
That is the
Where?
allegation of the,
In Meghalaya.
yes, my lord, that is the allegation of the detention authority. But the copy and the records of this case
Chart-
are not supplied to me.
Charge sheet is filed already, but you're on bail.
No, my lord, charge sheet has not been filed. I have not received a copy of the charge sheet.
Paragraph 7 of page 21. You are a habitual offender and you are earlier arrested in Maulai Police Station, Meghalaya, connection with FIR number so and so, dated 21/4/21. The case has been charge sheeted and you are currently on bail in the said case. That is why I'm asking you.
Yes, my lord,
This is what they say.
but I cannot be termed as an habitual offender, my lord. I've never been convicted in that case.
You are an accused only
Yes, I'm an
unless
accused.
you are convicted
Yes, my lord.
or a suspect.
Yes, my lord.
Okay, that is your case.
Yes, my lord. That is my case.
Then what about the other second one?
The same grounds, my lord. They were
Because
both
that-
arrested on the same
husband-
date.
husband, wife.
Husband and wife. Both arrested on the same date.
What do they do? Husband, wife,
Business, my lord.
business.
Yes, mobile shop. They run mobile shop.
Is there anything to that effect in the,
No, my lord. I have not mentioned anything. So
the FIR? What is that?
page 11, my lord.
Suomoto FIR. Yes. That's it?
That's all, my lord. This is
Okay.
my humble submission.
All right. Let's hear the other side.
May I please, Lordship? My lord,
in both the petition, the ground taken by the petitioner are same, so my submission will cover both the petition, my lord.
So you will kill two birds with one stone.
Yes, my lord. Yes, my lord. And my lord, I'm not going into the facts, my lord, only to the ground taken by the petitioner. I'll make my submission, my lord.
Yes.
My lord, in my affidavit, your lord, should kindly see my affidavit.
Your affidavit, yes.
Yes. Para 6.
Para 6. 6 is very lengthy. Divide into ABC.
Yes. ma'am.
You'll start from the beginning. Paragraph 6.
Yes, only paragraph 6.
Yes.
May I read, my lord? That with regard to the statement made in para 9, clause A to E, 10 and 11 of the writ petition are the grounds of submission of the petitioner are vehemently denied. The answering deponent humbly beg to state that deponent was well aware that the detainer was in judicial custody and fully satisfied the material placed on records, and after thorough application of mind, the detention order was passed directing the detainer to detain under section 22 clause B 60 NTPS Act in connection with the narcotic case number 5 of 2024. Clause A.
Is this correct? Section 22B/60 NDNPS Act.
Yes, my lord.
Yes. Section 22B. Let us see 22. Where is 22?
My lord, the seized item was around 239 grams. So if it is below 250, it is
Intermediate
coming-
quantity.
It is coming under 22 clause B.
No,
It's not
that
commercial, my lord.
that's okay. I was asking you something else. Detention under this section. 22B is not detention provision, isn't it?
Oh, yes.
Detention provision is under the prevention of illicit traffic and so and so. Section 3.1. So you should have written that he was detained under, she was detained under section 3, so and so. Anyway, what you mean was the registration of the case.
Yes, my lord.
Okay, anyway,
Yes,
yes.
And that in regard to ground number 1, that with regard to the one made in ground number A, the answering deponent is there that the representation dated 12/6/2024 was submitted by the detainer against her detention, and after careful examination, the detaining authority has rejected the detainer representation by order dated 13/6/2024 on the ground that there is no justified ground to revoke the order of detention, and subsequently rejected by the state government by order dated 18/6/2024. Simultaneously, the detainer representation was also forwarded to the advisory board on 12/6/2024, and accordingly, the detainer was heard in person by the board on 30/7/2024. And on careful perusal of the records placed before the board and considered the entire aspect of the matter, it was opined that the preventive detention of the detainer from engaging in trafficking of illegal narcotic drugs and psychotropic substance is justified, and further hold that there is sufficient cause for the prevention detention of the detainer. So, my lord, in the matter was forwarded, the representation was submitted on 12/6/2024. And that on the same day, the representation was forwarded to the advisory board. So advisory board was seated on 30, and the detainer was heard in prison, my lord. So, my lord, in the act, no way in the act it says that the decision taken by the advisory board should be communicated to the detainer. So it is to be submitted before to the state government. So advisory board has taken the decision, and the report was submitted to the state government, my lord.
When?
It was submitted on, your lordship, McCartney, the annexure A. Page number 8 in my affidavit. It was dated on 09/8/2024.
No, this is the date of report. It's not the
Yes.
date of submission to the government.
No, on the same day it was submitted because this is the date of report.
Is there a statement where? In your affidavit that it was submitted on the same day of report?
That statement I have not made, my lord.
Then?
But as per the record, it was reported on 9/18/24.
Date of sitting is 37.
Yes.
Date of report prepared is 9/8/2024.
Yes.
Date of submitting of the report to the government will be different unless you say specifically in your affidavit that it was submitted on this day itself.
Submission of that has not been mentioned, my lord.
Okay.
I have not stated.
But anyway, the fact remains that the report has been prepared.
Yes, so my lord here, in the act, it clearly says that the opinion of the advisory board should be submitted within 3 months or as per the section, it says that within 3 months.
Where is the
opinion-
section?
The lordship will kindly see the act.
Which part of the act?
Section 10. Section 10.
Cases in which? This one?
Yes, my lord. May I read, my lord?
Yes.
Section 10. Notwithstanding anything contained in this act, any person in respect of whom an order of detention is made under this act, at any time before that such and such may be detained under clause 4 of Article 22 of the Constitution, the opinion of an advisory board for a period longer than 3 months but not exceeding 6 months from the date of his detention. So the report was submitted accordingly within the period, my lord. So advisory board has not delayed, has in considering the representation submitted by the petitioner, my lord. So the first ground is there is no delay on the part of the advisory board in considering the representation because the report has to submit it before the state government. Second ground, my lord.
Now, since you already have the report.
Yes.
Affidavit is filed by whom?
By the special secretary.
So, where's the statement that we have received the report of the board also? Apart from enclosing the report. Anything like that?
Statement, I have not, statement is not, there is no statement in the affidavit, but the record is available, my lord.
You say that the report is 9/8/24.
Yes.
And it perhaps was given on the same date. Now we are in end of the month. Affidavit filed today. Any statement to the effect that the report has been accepted or has been considered by the government? Or that it remains just a report till date?
My lord, as per the record, the advisory board has already submitted. But the decision is basing on this report.
Beyond that.
Extension, yes, extension will be given, but that extension has not been given, my lord.
So whether the report has been accepted or not, that is not there.
Yes. So it will be accepted because as per the report, it clearly says that there is sufficient cause for detention, my lord. So further extension period of detention period of the petitioner will be based on the report submitted by the advisory board.
That's what. There's sufficient cause for preventive detention. Opinion is by the board. My
Yes,
question is whether that has been accepted by the government and acted upon or not. That is not available in your affidavit. is it?
Yes. That statement has not made, my lord. That is the justification in regard to ground number 1, my lord. And ground number 2, it's a ground number C.
Ground number one was not disposal of the
Advisor
representation.
vote.
Okay.
Yes.
And now ground number two?
Yes, in regard to subjective satisfaction.
Okay.
Yes.
Where is that?
Your Lordship may kindly say clause C in my affidavit.
But can you improve your case by affidavit?
No, my lord, I will rely on the record. I will rely, but I'm reading my statement made in the affidavit, my lord.
Okay, okay.
I will rely. But let me, kindly allow me to read this barasi.
Please read.
Yes, clause C. That with regard to the evidence made in ground number C is denied by the answering deponent. It is pertinent to mention herein that in the proposal letter dated 17/5/2024, Annexure C of the writ petition, in grounds of detention column, para 5 and 6, it has been clearly mentioned that the detaining authority was aware that the detainee was in judicial custody and likely to get bail if not preventively detained, and further likely to continue to indulge in illicit trafficking in narcotic drugs and psychotropic substance, and may not cooperate with the investigation agencies or hamper investigation if not detained. The FIR and the police report are valid documents containing the actual facts and circumstances of the case. The grounds of detention have been formulated by the detaining authority in line with the established facts and circumstances of the case. After careful examination or investigation of the case, the responding authority proposed the detention of the detainee under PIT and TPS Act, taking into account the serious aspects of the case which necessitated her prevention detention in the greater interest of the state. All documents relating to the case of the detainee were placed before the detaining authority, the Special Secretary Home. After careful examination of the established facts and circumstances of the case, the detaining authority was satisfied that the detainee is a trafficker of NDPS and likely to indulge in similar prejudicial activity unless prevented from doing so by an appropriate order of prevention detention. Accordingly, the detention order against the detainee was passed as per merit of the case and with full application of mine. Hence, the rights of the detainee have not been violated in any manner. My lord, in the detention order, it is not mentioned that he is likely to release him, but that in the detention order, I admitted. But in the proposal, my lord,
Proposal.
your lordship may kindly see the annexure C in the writ petition.
Page 17, paragraph 4 and 5
Yes.
and 6. This is what you want to show.
Yes, my lord.
Yes.
So in
That
the,
is your ground number 2.
yes, that is the ground.
Then number 3.
And number 3, in regard to the petitioner has submitted that the grounds of detention was not served to the detainer in the language she understands, my lord. My lord, in the clause number 3, it clearly says that the grounds of detention was explained to the petitioner, to the detainer, in the language she understands. That is the nakamis, my lord.
Where?
In clause T, your lordship, in the affidavit. And may I read, my lord? With regard to averment made in ground number T is denied by the answering deponent. The detainer had received a copy of the detention order dated 30/5/2024 along with its enclosure and duly acknowledged by the detainer on 3/6/2024, indicating that the detention order and other enclosed documents were explained to her in the language the detainer understands. That is Nagamis language. Your lordship may kindly see the annexure P in my affidavit. Page number 25. This is the acknowledgement certificate, my lord. Here it clearly says that the detention, the ground of detention was explained to her in the language she understands. That is the Nakamis, my lord. That is why since the ground of detention was explained to the petitioner, to the detainer in the language she understands, that's why the detainer has submitted the representation, my lord.
Yes.
So as per the pleadings, this is the three main grounds taken by the petitioner. And I've explained in the in my affidavit, my lord. So there is no violations or there is no illegality in passing the detention order, my lord. And whatever procedure prescribed in the act has been followed by the detaining authority while issuing the detention order. And in regard to the disposal of the representation by the state government, by the central government, state has nothing to say that because it is the
representation goes directly from the jail.
Yes,
Yes, my lord.
Not through the state.
From the jail, my lord.
From
Through the
the
jailer.
jail.
Yes,
To the
my lord.
jailer.
Through the jailer.
Yes, my lord.
What is the difficulty in proceeding as per the normal law, Indian PS, in such kind of case? 239 grams only. Had it been like a very large, big consignment and big business going on, I mean, just imagine that situation.
Yes.
Small quantity of this alleged substance has been recovered. They're also from somebody else. And that somebody else has point finger to these two persons. And they're picked up and they're detained.
So if we go by the facts, there is a involvement on the part of the detainee, my lord. So he's a habitual offender, my lord. So
Kingpin.
there is a prima facie. my
He's the
lord.
kingpin. Oh, what? Huh?
As per the statement given by the accused, co-accused and all, there is an involvement by the detainee, my lord.
What do you know about the other case in Meghalaya?
That one.
You don't know. No instructions.
I
on that.
don't know instruction. my lord.
Okay.
So this is the submission, my lord.
My lord,
Mr. Guli. What is your submission? That is your submission for the last few days. How long will you submit like that? No instructions. At least you prepare from the what is submitted by the other side. They have submitted a well-drafted petition comprising of all the materials. Even without receiving instructions directly, you should be able to submit that there are grounds of detaining him. It is not that he has been detained just like that. There appears to be grounds like that. Isn't it? You cannot wait for the central government to come and give you instructions like that every time. You have to prepare also. You've got the petition. From this itself, there are a lot of things to be said. So you don't want to submit? Yes. All right. Yes, counsel for the petitioner. Anything
my
to
lord,
say?
countering the submission of the learned government leader, that no report needs to be given. The advisory, no report of the advisory board needs to be given to the detainee. My lord, however, in the whole report, there is nothing that my representation has been considered. Nothing in the whole report.
Where is that?
There is nothing in the whole report that my representation has been considered. Now, here there is contradiction between the state government and the advisory board, my lord. There is nothing in the whole report dated 09/08/2024 that my representation has been considered, my lord, by the advisory board. There is nothing in the whole report.
No, but you have been heard in person, isn't it?
My lord, see, in the first para itself, now the state government in page number 4, para 6, clearly states that simultaneously the detainee representation was forwarded to the advisory board on 12/6/2024, my lord.
No, from where reading?
The affidavit in opposition of the state government at page number 4, para 6, at subclause A. It's clearly written that simultaneously the detainee representation was forwarded to the advisory board on 12/6/2024, and accordingly the detainee was heard in person by the board. But now, my lord, if you come to page number 8 of the report, here the advisory board report says something else. The detainee was heard in person. My lord, may I read page number 8, para 1. The detainee was heard in person both in Nagamis and English, and he has confirmed that he was provided with the grounds of detention along with the enclosed papers, and that he had not made a representation to the state government with respect to his detention, my lord. Contradiction between the state government and the advisory board, my lord. Therefore, my lord, the state government have never placed their representation before the advisory board for consideration. Therefore, nothing in the whole report stating that my representation has been considered. There's nothing in the whole report of the advisory board. And it is obligatory on the advisory board to consider my representation.
Do you have the records? Mr. Pom,
Record? No, I don't have.
you don't have,
I can bring it tomorrow.
you bring the records?
Tomorrow?
Yes. Have you got what has been submitted?
The advisory, my lord.
Your
advisory-
statement says that representation was considered by the government. And the orders there by the special secretary.
Yes.
And the chief secretary.
Yes.
And you also say that simultaneously it was given.
Representation
Was
was forwarded to the
forwarded
advisory board.
to the advisory board, my lord.
Yes.
Yes, what else?
But there's nothing in the report stating that my representation is being considered, my lord. Even in the report, silent.
Okay. Board is independent of the state, isn't it? There are two different entities. One is the state government, one is the board,
Yes.
one is the union government.
Yes.
So these three entities will have their separate consideration. And you only had said that even the union government can quash the
Yes, my
detention
lord,
order.
as per section 12 of the PIT and DPS.
So,
And even on the recommendation of the advisory board.
yes, any other reply?
Well, my lord, that representation submitted by the petitioner, that detainer will be, if the detainer has submitted representation, then that copy will be forwarded to the advisory board. And then only the advisory board will heard in person the detainer. That is the procedure. And the regarding the disposal, while disposing the representation, it is not necessary that like the state government, if the state government take any decision, it will communicate to the detainer that your representation has been considered or rejected. But in regard to the advisory board, there is no specific direction that that decision taken by the report should be communicated to the detainer. Only the opinion will be submitted to the state government.
So
And basing on that report, the state government will decide whether
So
to
what
accept.
is mandatory is for consideration by the advisory board. Isn't it? As per your submission,
Yes.
what is mandatory is that it should be considered by the advisory board.
Yes.
But it is not necessary that advisory board's opinion should be personally communicated. to
Yes,
the-
yes, yes. Yes, that is
They
the
may send
submission.
it to the government.
Yes,
The
yes.
Government may consider and
Yes,
pass
yes.
the extension order or
Yes.
whatever.
Yes. That is my submission.
Yes, my lord, but in the whole report, there is nothing that my representation has been considered, my lord. That is my humble submission.
So you produce the report tomorrow.
Okay.
We'll list it again, but no more hearing. Depending on after perusal of the reports, we'll pass the necessary orders.
Okay, man.
Okay. Your good name?
A. Sophie, my lord.
Heard Mr. A. Sophie, learned counsel for the petitioner. from Mr. E. Tivafo, Learned State Counsel, or as PP,
PP.
Learned Public Prosecutor, Nagaland, and Mr. ZN Muli, Learned CGC, for the Respondent Union of India. The parties have made their submission. List the matter again tomorrow to enable Mr. E. Tivafo produce the relevant records. You can produce tomorrow, isn't it?
Yes, my lord.
Done tomorrow. Just for the records. Okay.
For admission.
Item
Obliged, my
number-
lord.
Much obliged.
May I please, my lord?
Yes.
Lordship, Lordship, I don't know whether we have enough time to, otherwise this is ready for
State,
disposal. The state has filed an appeal
Against what?
against the judgment and order.
Writ petition.
Yes, Your Lordship.
What has happened? What kind of case is this?
Lordship, the,
Service?
no, Your Lordship. It's about payment of the pending bills of the petitioner, Your Lordship,
Okay.
of the writ petitioner.
Do you have any stay?
No, Your Lordship. Stay, that is why IA 80 is relates to stay. Your Lordship.
I think you can have it some other day, since there's hardly any time.
Yes, my lord.
You will submit, he will submit, then we'll also have to understand a bit.
Yes, my lord. That I can understand.
Is it possible to be listed, to be listed in the next available bench?
No, Your Lordship, because in fact, what happened was, my lord, this case got delayed up to today, for the fact that, Your Lordship, this particular writ petition, that is 86 of 2019, earlier, the single bench has disposed of the matter in the motion stage without letting the state contest the matter. Then the state filed a review petition, which was led by my Lord Justice Kohima. I assisted him in that matter, and the review was allowed, Your Lordship. Then the petition was recalled, and it subsequently got disposed of again, Your Lordship. And the state is aggrieved again, and therefore it cannot be listed before my Lord Justice Kohima. This is why it got delayed, Your Lordship.
And then my lord, the issue is that the state respondents as well as the center, they are not contesting that the contract work was completed. It's only that they're shifting the liabilities.
Not shifting the liabilities, Your Lordship. What the state is contending is that the state share should be paid by the state and the central share should be paid by the central. Here, what happened is, Your Lordship, all the liabilities has been shifted to the state government by the learned single judge. And therefore, this appeal, my lord.
What is to be done then?
Lordship,
Not possible.
not possible today, my lord. That's yes.
You want a date?
After 2 weeks, then, my lordship, because next week, my lord, Justice Kohima will be sitting again.
2 weeks.
Yes, after.
You can have it on 11th.
11.
Both of you are there. Both of you are there. We'll just say 2 weeks then.
Yes, ma'am.
Okay, my lord. Okay.
Let's wait for by the parties, list the matter again after 2 weeks. For hearing.
For orders,
I'm deeply obliged, my lord.
item number 13.
This is 13. Why is it listed for orders? No one. is this case? So. Yes, you were there.
Lordship.
What is this
For the
matter?
state, your lordship.
What is this matter?
The appellant, they are preferring an appeal against the judgment of a conviction passed by the session judge, a special judge of Dimapur. But actually, till now, your lordship, a copy has not been served to me, that read appeal. Only the bail application has been served to me.
No, not that, but it's criminal
A
appeal.
criminal appeal was not served to me. I'm sorry, your lordship.
Return service report from respondent number 2 is still awaited. Who is this? Tracking records are erased after 3 months. So it could not be tracked. Respondent number 2, who's respondent number 2? One is the state.
Yes, one is state.
Cheto Sumi. Is the number 2 a complainant?
Must be complainant, yes, your lordship.
What is the judgment otherwise?
The judgment is
Sentence and
convicted
order.
under POXO Act, your lordship. Is it page 28, bail application, it's at page 28, the judgment,
Oh.
sentence and order.
It's 20 years, that's why it's
Yes, yes,
before
Your
division bench.
Yes.
Under POXO, section 4. Number 2 is the complainant.
Complainant, your lordship.
There's a judgment of the division bench of this court wherein in case of POXO, the complainant or the support person is to be served to the complainant through the officer in charge of the police station,
Lordship.
and which has to be through the public prosecutor.
Lordship.
So a copy will go to you.
Yes.
Then you will give it to the
IO of the case, yes.
IO
yes.
of the case,
Yes,
and they
yes.
will serve a copy and
Yes, yes.
like that.
Yes, yes.
Has it been done in this case? Straight away, I think notice was sent. And
We'll have to check the first order.
then in such kind of appeal, this is not from jail. This is from outside. It's not a jail appeal, isn't it? It is not a jail appeal. So in such case,
Yes, yes, yes.
now how is the paper book prepared?
Yes.
Paper book is prepared by the registry
Appellant. Yes, by the registry.
at the cost of the appellant.
Appellant, at the cost of the appellant. Yes, your lordship.
Please write down. None appears for the appellant when the matter is called. Miss S. Mere, Learned Public Prosecutor, Government of Learned Public Prosecutor, Nagaland, appears on behalf of respondent number 1. And she submits that she has not been served with a copy of the memo of appeal. You don't have a copy?
No, no, your lordship. Only the bail application was served to me. The IA.
What
is
happened to
for
the bail? Bail is still pending?
During the pendency, yes, yes.
Okay.
Bail is to be taken up along with the criminal appeal.
And she has not been supplied with a copy of the memo of appeal. Next, para, it is seen that the appeal was admitted on 28/2/2024 and the records were called for. And further, the appellant was required to take steps for service of notice upon the respondent number 2, bracket informant. Stop. It is seen that the records have been received, but the respondent number 2 has not been served till date. Next para, in view of the order passed by a division bench of this court in Dash versus Dash, let notice be served upon the respondent number 2, bracket informant, through the officer in charge of the police station concerned. Copy of the notice in proper format be furnished to Ms. S. Mere, learned public prosecutor, by the registry, who shall then cause service of the notice to the respondent number 2 informant through the officer in charge of the police station concerned. Next para, the appellant shall also furnish a copy of the memo of appeal to the learned public prosecutor. Stop. Registry shall prepare paper book at the cost of the appellant. List the matter again after
3 weeks.
3 weeks. So they'll prepare a notice and give it to you.
Lordship.
You just send it to the OC.
Yes,
And after once he has served it, then you just get back to the court.
Lordship.
All right.
Yes,
Bail will consider as and when they appear.
Lordship.
Any more left? This was the last. Oh, there has been a. Councils are waiting. Oh, they are there.
Yes, Lordship.
I'll come back. Please be here.
Lordship.
Just many did you? What a particular time.
Friday, most likely whole day. Most likely.
Well, please, your Lordship.
For hearing, item numbers 1 and 2.
Your Lordship, I will only place the authorities
Yes.
on one point, that is the show cause notice. It should be specific. So even assuming that the summon can be considered as a show cause notice, language should be specific on how the action is to be taken against the person or the delinquent, your Lordship. So one judgment on that. This is 2021, 2 SCC, page 551,
You have a printout copy? Oh, okay.
Your Lordship.
Okay, then I'll note it down. Just a minute.
My Lord.
Just repeat again.
2021, 2 SCC, page 551,
Paragraph.
paragraph 13, 20, and 21, my lord.
This is on what point?
Your Lordship, that the language should be specific on what action is to be initiated against a person in the show cause notice or summon notice, in this case, Your Lordship. The person who is to be affected should be clear on what action is to be taken on him, and that very notice should specifically mention what action is to be taken against him.
Okay.
If
Then-
not, then it cannot be taken as, it cannot be considered as a show cause notice.
Okay, then.
Then, my lord, the other case is on the point of whether the section 9 of the Nagaland Village Council Act 9(1) should be read in isolation, and 9(3) also should be read in isolation or read together to give the meaning to the legislative intent.
9(1) and 9(3).
9(1) and 9(3). So according to my learned friend for the state, his submission is that it should be read separately. If it is read separately, Lordship, it will cause grave injustice. That is why I'm placing two judgments, Your Lordship, on the mischief rule of interpretation and the golden rule of interpretation, Your Lordship.
See, you can be disqualified from the chairman.
Your Lordship.
And also be removed.
As a member, Your
From the
Lordship.
member.
Your Lordship.
Now, in so far as this removal from the chairmanship, one
9(3)C.
ground, one
Yes.
ground.
Only majority.
No, one ground given there is that you cease to be a member of the village council.
As a chairman.
Yes. I think that's the one. 9.
So, Your Lordship.
9(3)A, my lord.
Here in this case, Your Lordship.
So why I'm asking you that is because you're saying that whether it should be read in isolation or together.
Yes, Your Lordship.
So.
Because, my lord, here in this case.
Going by this provision.
Yes, Your Lordship.
9(3)A.
My lord.
If he ceases to be a member of the VC.
But he was first removed as a chairman, Your Lordship. Removal as a member of the village council was subsequent, Your Lordship.
Okay.
So it's the other way around. So it is my humble submission that to give a
correct.
proper legislative intent, it has to be read
That
together.
is right. It was
So, Your
subsequent.
Lordship, 2015, 10 SCC,
2015,
10
10
SCC,
SCC,
161,
161, paragraph
24 and 27, my lord.
24 and 27.
And the other one, Your Lordship,
Yes.
2012,
On the same point,
yes, Your Lordship,
2012,
2 SCC,
to SCC,
page 489,
489.
paragraph 33 to 36,
Hmm.
38 and 40, my lord.
Okay.
My sincere gratitude to Your Lordship for considering our case even after the period of working hours
No, no,
finished,
no,
Your
no.
Lordship. That is my humble submission, Your Lordship.
That's all?
Lordship, only on the citation that he has placed, Your Lordship. Now, Your Lordship, in one of the citations he has placed, states about clear cut. What show cause has to be clear cut for which he is summoned or a show cause has been served. Now, Your Lordship, in the summon letter, 11th of July, it is clearly mentioned that the summon has been called for his termination as the VCC. So, Your Lordship, as far as that particular the citation is concerned, Your Lordship, it is clear in the summon letter, in the summon order dated 11th of July 2023.
Okay.
Your Lordship. The next issue is, Your Lordship, the writ petition that is removing him as the chairman, that is the WPC 169 will survive only when the WPC 1338 is allowed. For the fact that Your Lordship has just read it out, Section 93A says a person ceases to be a member, to be a village council chairman if he ceases to be a member. Now, he has already been removed as a member, and therefore the petition is here before this court challenging that by filing this writ petition 338. So if 338 survive, your lordship, or if 338 is allowed, then only, your lordship, WPC 169 survived. If 338,
It's the other way around. Look, first of all, he was removed from the chairmanship,
lordship,
then the membership.
lordship, whatever, your lordship, whether he was removed as the chairman first or whether he's removed as the as the member first, that is not what he is contesting. He is contesting on the ground that he has been removed illegally from both the chairman as well as the member. That is not that he was removed this first or this second.
All right, I'll consider and pass.
My
Lordship,
All right.
lordship.
I think I should reserve it.
Your lordship.
Heard Mr. Joshua Sheki, learned counsel for the petitioners, and Mr. N. learned state counsel for the state respondents, and Miss Nancy Lotha, learned
Respondent number
counsel
6.
for respondent number 6.
My lord.
Hearing is concluded or reserved.
Much obliged, your
Deeply
lordship.
obliged, my lord.
You show me those books, okay? I can give you printed, it's easier.